Monday.
Fresh matters next.
Can I, one suggestion, my lord. Can they parties be kept present, my lord?
All right.
Sunday.
Mediation refer model also.
ಇಲ್ಲ mediation ಬೇಡ ಇಲ್ಲೇ ಕರೆಸ್ಬಿಟ್ರೆ ಯಾಕಂದ್ರೆ
Mediation in any date also.
no, that will again drag on matter.
Parties to be present at 2:30 p.m. on Monday. Yes.
39 Shankar P. Hegde.
Seek lords weeks time lords objections ಬಂದಿದೆ.
ಯಾಕೆ ಬಂದ್ರಿ?
ಅಲ್ಲ ಅದು ಆಬ್ಜೆಕ್ಷನ್ ಆಗ್ತಾರಂತ ಆಕ್ಚುಲಿ ಫ್ಯಾಕ್ಚುಯಲ್ ಎರರ್ ಏನು ಇಲ್ವೇ ಇಲ್ಲ. Page number 95, even complainant has given a letter saying that he is not pursuing it because there is no material against me. And enquiry officer conducted detailed enquiry and submitted report, there is no material. Stay agide no material.
Yes.
Alla 18th ಅಥವಾ 19th
List on 21st.
Please.
Objections if any.
21st ಇರುವುದಿಲ್ಲ ಸರ್.
20th.
ಅಲ್ಲ ಇರುವುದಿಲ್ಲ. 19th or 18th.
ಹೋಗ್ತಾ ಇದೀರಾ?
ಪ್ರಯಾಗ್ರಾಜ್ 20ಕ್ಕೆ.
Yes. We'll take it on 24th then.
24th, 20th and 27th ಇರೋದಿಲ್ಲ ಸರ್. 18th, 19th or ಅದಕ್ಕಿಂತ ಮೊದಲು
ಒಂದು ವಾರ ಹೆಂಗ್ ಹೋಗ್ತೀರಾ ನೀವು? Yes. List on 19th.
Obliged.
ಅವತ್ತೇನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿರಲ್ಲ ಅವ್ರು interim order ಇದೆ ಹೆಂಗೋ? Yes. List on 3rd March. Interim order subsisting will continue to the next date of hearing. Next.
Silma 40 Vishwanath Hegde CVMD.
Please.
I represent all the three respondents, oil marketing companies. The matter
Issue about 8 crores of money which is due to me has been withheld by the respondents on the count that an entry tax may be leviable by the state government with respect to supply of the degenerated ethanol by me to them on the presumption that it will be charged. Now that issue has been attained as finally in the CRP which was filed by them, wherein this honorable court has held that even so far as denatured ethanol is concerned, there is no question of entry tax. But that order has attained finality. Now I am told that they have filed a review. On that count, they are not releasing my money. Even in the writ petition that is filed by me.
By an interim order, can I direct release of?
No, not an interim order, it's for final disposal itself.
Firstly, my lord, the review petition has been filed. In fact, this
Justice Hemant Chandan Gowda order is covered.
How this that is writ petition was filed by me. If my lord should please turn to page 50.
Division bench ಏನಾಯ್ತು?
Division bench there's a CRP which was filed by them.
Page.
That is at page starts at page 52. Operative portion page 62. Para 14.
Any change or confirmed?
No, no. They are also the same issue.
Answered in favor of the SSC and against the revenue.
Against the revenue.
All right.
Now what the respondents say at page 103, they issue a reply to me stating that there is a review filed by the department, therefore you have to await it. And they say I have to pay the expenses for the litigation that they have incurred. Page 103, if please turn to.
Page
103. How? 103. They admit that the amount is withheld by them. But this period is of 2007 to 2009, Lord. They still not withholding my amount.
My lord, as the tender was floated, my lord, the petitioner was one of the successful bidder.
So you filed review against what order, sir?
Against the order passed by the KT, my lord. In fact,
KT?
Yes, my lord, appellate tribunal. In STA case number, my lord, that is
that?
My lord,
But that's at page 64.
Idea of the page 45 order.
But page 45 order is a writ petition which was filed by me as against the clarification that was issued by the state government saying that entry tax is applicable.
1 minute.
my lord, I have the
One,
copy
you
of
are
the
saying
order.
that it's already decided.
That is not CRP, where it is filed by the respondents themselves, which is at page 652.
Yes, my lord.
IOCL is the first petitioner in that matter. The other petitioner is at page
BPCL.
53, that is BPCL.
Lord,
Both of them are parties there. But here the third respondent is the other company. But the issue is the same.
ಇದ್ರ ಮೇಲೆ ರಿವ್ಯೂ ಹಾಕಿದ್ದೀರಾ ಈಗ?
Iವರು ಹಾಕಿಲ್ಲ. They have succeeded.
the
They
revenue
have
has,
succeeded
the
in this.
revenue has preferred.
Succeeded and the division bench has set it aside.
Yes, Lord. Now that is
ರಿವ್ಯೂ ಹಾಕಿದ್ದಾರೆ, ಯಾರ್ ಮುಂದೆ ಹಾಕಿದ್ದಾರೆ?
No, review has been filed by the department, my lord.
Before whom, which court?
Before the division bench at Bangalore, my lord. This I have the copy.
Yes.
It is pending, my lord.
ಇದು ಸೇರ್ಸಿ ಹಾಕ್ಬಿಡಿ ಅಲ್ಲಿ.
My lord, my submission here, my lord, the
Stay ಇದೆಯಾ? ಈ ಆರ್ಡರ್ ಸ್ಟೇ ಇದೆಯಾ?
I'm not aware of it because we are respondents.
ರಿವ್ಯೂ ಹಾಕಿದ್ದಾರೆ, ಯಾರು ಹಾಕಿರೋದು ರಿವ್ಯೂ?
Review is preferred by the revenue, my lord. The order is passed in favor of the OMCs.
That's all right. Should you not get information as to what is the status? I'm going
Just
to.
notices
I'm
have
going to
been.
allow this.
My lord,
Notice ಅಷ್ಟೇ
my
ಅಲ್ವಾ?
lord, my lord, I have to file my statement of objections because
ಏನಿಲ್ಲ ಅಲ್ವಾ?
not only notice have been ordered, that is not my submission. I have to, my lord, the money is not with me. We have remitted to the department. We have requested them to release the amount. They have written saying that review petition has been filed. My lord, I have to place on record the copy of the tender notification, the terms and conditions, who has to bear the taxes. And moreover,
If there is
government is
determination-
not.
If there is already a determination by the division bench, you think I'll go against it?
My lord, the order passed
What
by the.
makes you think I'll go
My lord,
against it?
The order passed by the division bench in CRP number 88 of 2014, 196, it is in favor of the OMCs, my lord. The respondent number 1 and 3 in the instant petition. It favors because the notice was served on the respondents to pay the taxes. And then,
Who has filed review?
my lord, I have
It
to.
is filed by the state government, Lord.
State
They
government
have
has filed.
succeeded not in the petition. In
Correct,
fact,
but
not
that
my
amount-
writ petition,
my
but
submission-
against the state government, I have succeeded.
No, firstly,
I'll-
my lord, the Commissioner of Commercial Tax is a necessary party, my lord. The amount is with them. We have remitted to the department.
That is
We are
between
asking
them. They have to give me back my money which they have withheld.
State is not a party here.
Not a party, my lord.
No, state not,
ಮಾಡಿ.
no, my lord, state,
Lord, one
my
section-
money is not withheld by them. But there is no dispute on
By
that.
whom?
The
VPC,
respondents
IOC or
hearing.
who?
All the three respondents.
We are not withheld.
I have
we are
also
remitted
pointed
to
out
the
how
department.
much amount is retained by each of them.
I have certain objection. Either
Not
let him
my money.
allow me to speak,
To
otherwise he's interfering while I am making submissions. My lords asked me to make submissions. So that's not the way to address the honorable court, my lord.
Seriously.
No, seriously,
Both
my
of you
lord.
should know that, yes.
Let him first complete the necessary respondents, my lord.
File your objections.
I'll say.
Yes, next Friday.
My lord, 2 weeks, my lord, because I
Next
have to
Friday
take from
in the fresh
all three,
matters
all three respondents have to file, my lord, 2 weeks, my lord.
All three will not file three different objections, sir.
It's the same, at least 10
So,
days, my lord.
Get one.
Because one concerned officer is sick, is hospitalized.
Yes, no problem.
10 days, my lord, I'll file.
No, sir, next Friday.
Please.
Yes.
But in the meantime, let him be directed to make party, my lord, the
Friday we'll
commercial.
see.
Yes,
Yes.
please.
Number 41, Sadiq in Gudwala, Girish is full money.
Around my lord, they do. Rejection.
Yes.
What? Today, my lords.
Please, Lordship.
Regularization.
Yes.
Day before yesterday, I filed the Wakalat Lordship. 10 days time, Lordship.
Yeah, 25 da.
Please, Lordship.
10 days time is
Since
granted to
from,
file. Yaಕೆ
since
objection
from
ಬೇಡ?
2006 onwards
No
there.
problem, sir. Objection ಹಾಕ್ಬಾರ್ದು ಅಂತಿದ್ಯಾ ಅದಕ್ಕೆ?
No, no, in the earlier round of litigations, my lords, not a single objection has been filed.
Yes.
And one
List, 10 days time is granted to file statement of objection.
Please, Lordship.
date may can be fixed.
Data.
Yes.
ಇನ್ನು instruction ಬಂದಿಲ್ಲ. Day before yesterday, I filed the Wakalat Lordship.
Yes.
My lords, I have it on 27th, my lords.
March. Yes.
First week of March.
Move ಮಾಡಿ next bench.
No, it's covered by lordship's judgments.
No, maybe. I have, 2 or 3 I have reserved. If I write that it gets covered, wait. Yes.
Please, Lordship.
Yes.
Apply, Lordship.
Number 42, Sadiq in Gudwala, Girish is full money.
It may kindly take a next week, my lords. Council is out of station. Interim order may kindly.
Surface proceedings.
Yes, my lords. My lords,
See council, my lords.
OTS. Just on Monday in the fresh matters list.
Please.
Yes. Stay ತಗೊಂಡ್ಮೇಲೆ ಮತ್ತೆ ಕೊಡೋಣ.
Interim order may extended.
ಅದಕ್ಕೆ till Monday. Yes, next.
43, Suresh is Bhatt.
I appear for the council for the petitioner.
May I seek short accommodation, your lordship, to instructions, your lordship. This is the matter pertaining to.
This in the first week of March. Interim order subsisting will continue the next date. Next.
44, K.S. Patil.
The state wanted to be file my lord, statement of objection in Tuesday it is there.
Case Patil.
State to,
ಇಲ್ಲ
they need to be extended, my lordship.
Interim order is
Tuesday it
there.
will be-
And a wife, husband and wife.
wife ಅದೇ affidavit that the turnover and balance experience.
You have to file.
No.
List in the first week of March. Interim order subsisting will continue to the next date of hearing. Next.
45, Sridhar Prabhu. Again,
Lord.
Gudwala.
I have instructions, my lord, for
Connected by this honorable. Other matters may be tagged with this matter, my lord. Connected matters.
my lord, I have instructions to appear for respondent 3 to 7.
Interim order may kindly be
Interim order
extended.
subsisting will continue to the next date.
Please.
56, Girish V. Bhatt.
Matter, my lords, the petitioners are the laborers.
2 weeks time to file objections, my lords.
Orally terminated 2009. I have challenged it, my lord.
The Learned Council seeks 2 weeks time to file statement of objection.
Permitted, my lords. After
Orally terminated in the year 2009.
15 years I have sort of in the court. Now they have issued the reinstatement order, my lord, stating that, my lords, I will be removed at any time without any prior notice.
E court direct ಮಾಡಿದ್ದಾರೆ reinstatement.
Labor court ಅಲ್ಲಿ ಗೆದ್ದೆ ಅದಾದ್ಮೇಲೆ they have challenged it before this honorable court. Then they went up to writ appeal, went up to the honorable apex court.
The petitioner is aggrieved by a particular clause which directs that he can be removed at any time on such reinstatement. The petitioner apprehends that that can be used against the petitioner at any time. Though interim order is not sought in the case at hand, I deem it appropriate to direct the respondents not to invoke the said clause during the pendency of the petition. Yes.
Grateful.
Interim order ಕೇಳಬೇಕು ಮತ್ತೆ ಅದನ್ನ interim order ಕೇಳಬೇಕಾಗಿದೆ.
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅವರು ಉಳಿದ ಬೆನಿಫಿಟ್ಸ್ ಯಾವುದು ಇಲ್ಲ ಅಂತ ಹೇಳಿದಾರೆ. If I admit it, they may go against us ಅಂತ ಕೇಳಿದ್ರು. Please.
Next.
47, Shivraj C. Ballaki. Shivraj Balloli.
Lords, 2 weeks time to file objections, please.
I appear for the petitioners, your lordship.
Rest in the first week of March, interim order subsisting will continue to the next date.
Please, my lords.
Next.
48.
Shivraj Balloli seeks 2 weeks time to file statement of objections.
Lords,
Interim
can
order
have it in the second
subsisting will
week, your
continue to the
lordship.
next date.
Lords, can have it in the second week, your lordship.
For the submission. Senior was making some submission.
ಯಾವ್ದ್ರಲ್ಲಿ?
Lords, can have it in the second week, your lordship.
There's some problem.
Yes, sir. Lords, can have it in the
Not audible. Not audible, sir. Unmute.
unmuted only, your lordship.
ಇಲ್ಲಿ ಬರ್ಲಿಲ್ಲ.
My lords, can have it in the second week, your lordship. Your lords are able to hear me?
Will
ಅದು ಬಿಡಿ ಸರ್, ಅದು ಮೋಸ್ಟ್ಲಿ ಪೆಂಡಿಂಗ್.
ಅವು ಲಾಸ್ಟ್ ಟೈಮ್ ಫೋನ್ ಮಾಡಲಿಲ್ಲ ಅವ್ರಿಗೆ.
9/2020 ಹಳೆ ಮ್ಯಾಟರ್.
ಅದು ಬಿಡಿ ಸರ್.
ಯಾವಾಗ ಮಾಡಿದ್ರು?
ಮೊನ್ನೆ
34/23 ಅದು ಕೋರ್ಟ್ ಮುಂದೆ ಹಿಯರಿಂಗ್ ಬಂದಿತ್ತು ಅಡ್ಮಿಷನ್.
ಅದು ಕೋರ್ಟ್ ಫೀ ಎಷ್ಟೇ ತಾನೆ ಸರ್?
ಕೋರ್ಟ್ ಫೀ ಅಲ್ಲ, ಬೇರೆ ಡಿಫೆಕ್ಟ್ಸ್ ಇದೆ.
ಅಲ್ಲಿ
34/23 ನಾ?
ಹಾ
ಸರಿ.
2 KVG ಬ್ಯಾಂಕ್ ಅಂತ ಹೇಳಿದೆ.
ಕಂಪ್ಯೂಟರ್
9/20 ಗೆ 34/23
ಬರ್ಲಿಲ್ಲ ಅವರು.
ಮೊನ್ನೆ 34/23 ನೋಡಿ ಮೇಡಮ್.
I'm awaiting instructions to file objections also.
ಡೇಟ್ ಕೊಡ್ತಾ ಇಲ್ಲ. Yes.
Please.
Interim order.
Oblige.
One of the skip.
Send some documents. You have to prepare a note for Rajaramji for 20. I will also go to I will also go to
I'll tell you what
because
Tender
you don't have that level of information about this.
Sir, I am declared as L1, my lord. Now they have issued a fresh tender.
There's some grants. I don't know what.
Seek some. Already there is an interim.
There's labor meeting on 28th.
For the petitioner.
All their economics. What are those JNU people? They're all very economists.
Interim order.
Interim order is there, my lord. They are unnecessarily calling the second tender, my lord. When I am
stay ಮಾಡಿದೀನಲ್ಲ.
Stay ಮಾಡಿದ್ದೀವಿ.
Supply ಮಾಡ್ತಾ ಇಲ್ವಾ ಈಗ?
ನಾವು ಮಾಡ್ತೇವೆ.
ಅಯ್ಯೋ ಮತ್ತೆ ಮಾಡಿ ಇನ್ನೊಂದು ಆರಾಮಾಗಿ. Yes, Mr. Computer, come here.
Yes, Mr.
ನಿಮಗೆ ಅಡ್ವೊಕೇಟ್ಸ್ ಮುಖ ನೋಡೋಕಲ್ಲ ಕರೆದಿದ್ದು. ಅಲ್ಲಿ ಬರ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿದೆ ಅವಾಗ. ಯಾಕೆ what did you do? And ಫೋನ್ ಮಾಡಿದ ತಕ್ಷಣ ಬರಕ್ಕಾಗಲ್ವಾ?
He's telling the RG computer. calling him Mr. Computer. No, the guy who was in charge of that. But I'm telling you, Dharwad is. What is this? Yes, Mr.
Petitioner being aggrieved by the order passed annexure M by respondent number 2 is close. We are filing memo, my lords, along with photographs to show the demolition as per in compliance of the order.
The encroached area has been removed. Now, my lord, the impugned order, by virtue of the impugned order, he was in excess of 398 square feet. What was allotted to him was 595. He was excess of 390 square feet. Lords, therefore, several notices were issued to remove that. He did not do it. Under the agreement, my lords, we had imposed penalty also. Now, my lord, since he did not even pay the penalty, we've passed an order cancelling his license. Now, my lord,
the bone of contention is gone.
yes.
Now
What remains now, my lords, is that license agreement was cancelled and he was blacklisted for 2 years. Now, my lords, that will not, my lords, press, provided he pays the penalty because he has used that property for, my lords, a considerable amount of time.
My lords, our contention is we had also submitted several representations, my lords, asking for the remeasurement as to know how much excess we have been using.
Both of you are on.
But there have been procedural lapses from their end also.
Both
My
of
lords.
you
Can
are
continue.
So, penalty ಎಷ್ಟು ಬರುತ್ತೆ?
3 lakh.
3 lakh 1,000 they have
3 lakh
imposed.
is
That
not
is
the
triple penalty, my lords. From the annexure G, there was 1,23,000, my lords.
ಈಗ ಕೊಟ್ಟಿದ್ದೀರಾ ವಾಪಸ್ಸು?
No, it is still under our possession.
They have
but
seized,
if
my
he pays
lords,
the
seized
penalty,
the
my lord, let him continue for the entire license period.
He will pay the penalty not at one stroke. Business ಮಾಡಕ್ ಬಿಟ್ರೆ ಕೊಡ್ತಾರೆ ಆಮೇಲೆ.
My lords,
So, in fact,
3
it
lakhs
was-
is
3 lakhs
exorbitant.
Penalty not 3 times, you know.
My lords,
First is blacklisting will go.
and license, my lords, will continue for the rest of
License
the
will
period.
continue.
10 years.
And you will seek instructions at how will compensate for
Yes.
the allegation that
Yes.
is there. Not 3 times penalty, at least 1 time you have to give.
Lords, the way it is
Because
calculated, my lord says,
because in the terms and conditions, my lords, of
So violated
e-tender,
the terms and conditions, ಅದಕ್ಕೆ ಅವರು ಮಾಡಿರೋದು.
ಅದರಲ್ಲಿ ಇತ್ತು, if there is any danger, the possibility of danger, ಅದು ಏನೇ risk ಇದ್ರು, it was on the petitioner, my lord. Just for the sake of not having any dangers of the transformers near, which is so close by to the premises, my lords, that compound wall was raised, my lords, which was already existing in the premises. ಅದು ಸಂಸ್ಥೆದ ಕಾಂಪೌಂಡ್ ಇತ್ತು, ಅದ್ರ ಮೇಲೆ ನಾವು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಕೊಂಡಿದ್ವಿ. It was not a new wall that was built altogether, my lords.
my lords,
And in spite of giving several representations, my lords, it was not considered.
Now you seek instructions, give them the space.
Please.
Let them come up with a affidavit or something that you sit across with them. 3 times penalty, what penalty can be imposed, not to file an affidavit.
amount of penalty, my lords,
Penalty.
penalty is imposed because, my lords,
Minimum we can pay, my lords,
The
because there have
calculation
been procedural lapses from their end also,
You
my
are
lords.
all right.
Yes,
Now sit across and see what can be done.
please, please.
On Tuesday or Wednesday, I'll take. By then, restore possession.
please,
Continue
let
the
there be an
license.
order, my lords, for restoration of possession.
Yes.
The petition, this court on so and so had passed the following order. The learned counsel appearing for the petitioner submits that the bone of contention that was projected in the earlier order has now been removed. And the wall has been broken. The learned counsel Prashant Hosmani submits that what remains is the petitioner to pay penalty. The penalty, which is now assessed at 3 lakhs
1,000.
3 lakh 1,000. The learned counsel for the petitioner projects certain procedural violations also at the end of the corporation, admitting certain violations at the end of the petitioner as well. Therefore, the parties to sit across and arrive at an amicable settlement, if any, with regard to the quantum of penalty that is now imposed. In the interregnum, the corporation shall restore possession to the petitioner, continue the license subject to further orders that would be passed by this court. List on 21st.
Please.
Yes.
Number 50, Saurabh Hegde, BS Compton.
Lord, I am not the existing tenderer, my lord. Now, they will take advantage of it, my lord. That is the reason.
I thought you were supplying.
No, I am not the supplier.
21st,
Out
Lord.
of the 3.
21st.
Ablash.
Lord, this actually excess recovery amount, my lord.
Today I have received the instructions. I undertake.
Excess recovery.
I undertake to file wakalat
And
and
further,
also get the instructions.
further
Yaar,
continuation.
VS Corporation ga.
ಕಣ್ವಿ ಸರ್
Council MB Kanvi submits that he is would undertake to enter appearance for the respondent. Which respondent?
1 to 3.
1 to 5.
1 to 5 in place of BS Kamte. Registry to delete the name of BS Kamte. List on 21st in the fresh matters list. Please.
51 is ticketed 30.
My lords, I am filing interim application to be implemented as respondent number 5 and 6.
Who are you, sir?
My lords, I am the owner of the adjacent land number, serial number, survey number 88, my lords.
Police protection.
Police protection, my lords. My lords, I am producing the map, the ADLR PT sheet and all the other documents may kindly peruse, my lords. Though, my lords, there exists a government road, my lords, as per the map of the Mudalgi village. What they are doing is, my lords, I have grown crops, standing crops.
We are concerned about there is the problem with assault or something.
Road, my lord. That's why I said they are claiming under the from the
by
land of the another
encroaching into
person.
my land, my lords, my standing crops are there, and now they have sought a interim order without making me as a party, my lords. They intend to enter. Lords,
to give police protection to-
ಕೊಟ್ಟಿದ್ದಾರೆ, my lords.
Police protection.
Please, my lord.
ಕಪ್ ತಗೊಂಡು ಹೋಗ್ಲಿಕ್ಕೆ.
My lords, now,
Suit
my
is
lords,
filed, my lord. Suit is filed. They have appeared. TI is
Ex parte
extended
TI,
from
my
time
lords.
to time. Still, my lord, they dismantled the road by pouring the water. I cannot, my lord, transport the sugarcane crop standing in 8 acre, 27 guntas. They, my lord, even after police protection, they threatened the laborers.
my
When they
submission
have
is, my
visited the
lords.
We have provided
Who
police
is pending?
Yes, my lords.
You have suffered an order against you.
Ex parte TI
All
is
right. Then continue. ಯಾವಾಗ ಆಗಿದ್ದದು?
ex parte TI, my lords, is past, and my
19-3
lords, I have
ಇದೆ.
filed an, my lords, I have filed an objection, my lords, since the magistrate.
What's the ex parte?
Please, my lords.
7/11/23.
7/11?
Ex parte.
Please, my lords. My lords, the physical difficulty is that,
No difficulty.
my lords, the magistrate is not, regular sitting is not there, my lords, and the in-charge court is not taking up my hearing, my lords.
Challenge it, sir.
My lords,
Challenge it.
next what has happened is my standing crops are there, my lords.
Challenge it.
Please, my lords.
If there is no sitting there, right time to approach the High Court, get challenge it.
Yes, my lords. And now what has happened, my lords, though there is a government land and the petitioner himself has conducted the survey and survey report I have produced, my lords. Government land, government road idru kuda, he is entering upon my land, my standing crops are there, my lords. Sadaka crop is grown, my lords. I have produced the photos also.
Whatever it is, he is the person in whose favor there is a temporary injunction, whether it be ex parte or otherwise.
Please, my lord.
It is operating for the last 15 months. I only directed police protection to be given in the teeth of the TI in terms of circular of government 4/11/2018. That is all. If you have any squabble with him, do it.
Yes, my lords. Even I will challenge that order, my lords. But though, my lords, there is a road, my lords, to enter his land, my lords. He is leaving that and he wants to destroy my crops and want to enter his land, my lords.
You take action, register a crime.
That's why on last day also I submitted the same thing.
If that is what the petitioners are wanting to do, register a crime against them. Yes, sir.
Now, your lordship may appoint anybody. If my arrangement saying that there are government roads, I have absolutely no problem. Let the somebody
there,
inspect
for a while,
and submit
my
a
lords.
report with videography.
For a while, my lords.
I have no objection.
Now, if the earlier order will remain, yes.
We have given police protection. ಕೊಡ್ತಾ ಇದೀವಿ. ಇವತ್ತು ಇದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
In real time, I have told. You have a squabble.
They require, my lords.
He has an injunction in his favor. Circular says he has to be given protection.
My submission is, my lords, one date may kindly be given, my lords, till Monday or Tuesday, my lords, till that day, my lords. If status quo is maintained, my lords, the sugar cane, there will be no loss, my lords. But my lords, 5 guntas of my sadaka growing crops, my lords.
Civil court.
In this case, my lords, we are already giving police protection. And as per, my lords, the instructions, within 2 to 3 days, my lords, their sugar cane will be sent to the.
You are disturbing his crop and.
No,
my
lords. I have produced the photos, my lords.
That is a report by the police. I will direct them to register the crime against you.
My lord, team lord, I visit the spot. If roads are available, my lord, as submitted my lawyer friend, action to be initiated against the petitioner.
My lords, my one submission.
I have no
is, my lords,
objection.
Here, my lords, I have produced that photo. Here, my standing crops are there. He intends, my lords, to take his tractor over here and reach his land, my lords. My lords, my standing crops are there. 5 guntas of sadaka crop, my lords.
But I have produced 2-3 photographs.
Don't disturb his crops.
No, my lord, absolutely no, my lord.
With regard to that,
the learned counsel for the respondent submits that the petitioner is deliberately wanting to draw the tractor onto the standing crops on the imaginary plea that there are no roads to enter to his property. The learned counsel for the petitioner undertakes that the petitioners would not disturb or destroy any crop of the impleading applicant.
Yeah, 5 and 6, respond number
of
5.
any crop of respondent
Impleading.
5 and 6. The police, while granting such protection, shall oversee such activities.
Please.
Yes, next.
And I may be directed to be impleaded as a party, my lords. Without making me as a party, they have obtained the interim
The
order.
impleading applicant and
Yes, my lords, impleading applicant.
impleading applicant. Yes.
It may be allowed, my lord. I have no objection.
Impleading application for the reasons indicated in the affidavit accompanying the application. Impleading application in IA number so and so stands allowed. The petitioner to amend the cause title forthwith. List on Wednesday.
Please,
Lord, in the one, Lord, I have given the sketch suit, Lord, along with, in the suit, that is to be clarified.
Next.
Please.
Of course, in the suit schedule property.
Yes.
Correct.
Please.
Much obliged.
Next.
Bill number 52, VR Sarthi.
Waiting for the petitioner. This case, my lords, seek my lords 2 weeks time.
Mandamus 92 days,
Only thing is the prayer which I am seeking is only to remand the matter without even putting on notice. They cancelled it off. Hampe heritage. The only fact is, your lordship, they in 2000.
That I have heard you. Give you 1 week's time. If you don't file, then I will pass out.
Because 18th they have issued notice to me to submit the report, and the notice is issued on 18/3. 23 without even
list on 21st. Yes.
24th.
24th in the fresh matter.
Instead of 24th, 20th, your lordship, I posted for other matters.
You will ಬರ್ತಾ ಇದ್ದೀರಾ?
20th.
20th ಯಾಕೆ?
ಮೊನ್ನೆ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ 20th ಗುರುವಾರ.
Objections ಮತ್ತೆ ಅವರ ಟೈಮ್ ಕೇಳ್ತಾರೆ.
ಇಲ್ಲ 27.
See, interim order ಕೇಳಿದ್ರೆ ಬೇರೆ ಮಾತು. Interim order ಕೇಳಿಲ್ಲ.
Only thing is we are seeking for remand.
That is why ಅದಕ್ಕೆ objections ಬೇಕಲ್ಲ. Yes.
Because without even having issued a notice.
So if he has justification, we'll see.
On record itself I can establish.
Record ಸರಿ. ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಬಂದ್ರೆ ಏನ್ ಮಾಡೋದು?
ಅದು ಹೇಳ್ಬಿಡಿ.
ಅದಕ್ಕೆ objection ಆಗ್ತದೆ.
That is the only.
24th.
ಆಗ್ಬೋದು.
53, Nataraj Ballal.
ಇದೇನು?
ಇದರಲ್ಲಿ ನಾವು NSIC.
You are supplying?
No.
ಇದರಲ್ಲೂ ಇಲ್ವಾ?
We are all from
call to.
Yes, my lord. In the second call, my lord, they reject my tender,
yes,
even
same.
without assigning any reasons.
24th.
Please.
Objections, if any, by then interim order subsisting will continue to the next date of hearing.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಒಂದು 21st ಗೆ ಒಂದು 24th.
ಅಲ್ಲ ಅದು 24th ಗೆ ಹಾಕ್ಬಿಡ್ತೀನಿ.
24th, please.
ಅದು yes. ಯಾವ್ದದು ನಟರಾಜ್ ನಿಮ್ದು?
Next. Serial number 48.
48 to 24th ಗೆ ಹಾಕಿ. Yes, next.
54 Arjun, 55 Prashant Gowda.
This case, my lord, central government, ASG wants to appear.
Yesterday's matter.
No, this is a fresh release order they are seeking.
Nenne 2:30 move ಮಾಡಿದ್ರು.
I think ASG wants to appear.
ASG?
Additional Solicitor General, Arvind Kamath wants to appear.
ಇರಲ್ಲ.
Yes, they just message on 20th, my lord.
All right.
Because they, in fact, caveat were filed by Mrutyunjay Hallikeri. So in fact, it was kept in my.
Both.
20ನೇ ತಾರೀಕು.
ಅಲ್ಲ ಯಾವುದು 55 ಆಮೇಲೆ
50 57 he is not concerned. 55 I am seeking only for the permission to sell.
ASG wants to appear.
ASG wants to appear.
Just on 20th.
Please.
Yes.
Similar orders are already passed.
That's what. Similar.
No, they, my lord, those were prior season, my lord. In fact.
Oh, no. I have passed so many.
No, I am sorry.
No, caveat were filed, my lord. In fact, all sugar factory in state of Karnataka and other states,
We
my
are not
lord.
challenging that notification at all.
Your lordships may have it on 20th, my lord.
Same order. I have
No,
to pass
your
in
lordships,
every case.
No, my lords may kindly.
Unless I sell that sugar.
No, your lordship, nothing is.
Farmers ಕೊಡಕ್ತಾ
ಇಲ್ಲ interim prayer ಬೇರೆ ಇದೆ, my lord.
No.
ಅದರಲ್ಲಿ ಇಲ್ಲ, my lords.
No, interim prayer ಬೇರೆ ಇದ್ರುನು I have myself granted so many orders.
No, my lords may let it be, my lords, sir.
No, just because you are asking the interim orders.
No, I am not on this. Since my lord caveat were filed.
That's that caveats are filed. You should have seen the caveats are put up.
Caveat was filed through Mrutyunjay Hallikeri, my lord.
Whoever it is, sir. If caveats are filed, you should have seen to that caveats are put up. There are interim orders granted left.
No,
right,
yes,
center,
my lord, they want to make submission, my lord.
That is subject matter of challenge in 57.
Monday, fresh matters list. Yes.
ಇದರಲ್ಲಿ ಏನಾಗ್ತದೆ ಅಂದ್ರೆ I am asked to
Allah.
run 100.
Monday I am going to grant. If you want to
Yes,
come on
my
Monday.
lord, in fact, the instruction, I was not having instruction.
If you want to appear on Monday.
learned
Yes,
friend
yes.
himself appeared in other matters.
Allala,
Where he got
this
orders
sugar
in
fact, my,
earlier round.
Granted,
allala,
everywhere.
hangeniಲ್ಲ. My father was also the founder of the sugar factory. I know about
What,
it.
sir?
Long back. Let it.
List on Monday in the fresh matters.
This even along with 57, my lord. That's
57, same.
a recovery
Yes.
certificate has been issued.
55 and 57 both.
56 ಶ್ರೀನಾಥ್ ಪಚಾಪುರೆ
ನಂಬರ್ 6 24
ಆಯ್ತು, ಎಲ್ಲ ಸಾರಥಿದು ಯಾವ್ಯಾವ ಇದೆ ಎಲ್ಲ ಹಾಕ್ಬಿಡಿ ಅವತ್ತು.
24
ಸೀಲ್ ನಂಬರ್ 6 24th ಗೆ ಹಾಕಿ.
ಇನ್ಫಾರ್ಮ್
ಓ ದಟ್ ಯೂನಿವರ್ಸಿಟಿ ಮ್ಯಾಟರ್ ಅದು ಹಾಕ್ಬಿಡಿ.
Here petitioner seeking mandamus, my lord. But he was petitioner was tried for offence under section 3 and 7 of Penal Community Act.
ವಾಶ್ ಆಗಿದೆಯಾ?
Quash acquitted, my lord. On trial acquitted.
ರೈಸ್ ಇನ್ನೂ ಇರುತ್ತಾ ಅಲ್ಲಿ?
ಒಂದೇನೋ ಇದು ಮಾಡಿದ್ದಾರೆ.
ಪೆರಿಷಬಲ್ ಕಮಾಡಿಟಿ ಏನ್ ರೈಸ್ ಇಟ್ಟಿರ್ತೀರಾ?
ಅಲ್ಲ ರೈಸ್ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೂ
But the equivalent to that rice, my lord.
Petitioner is before this court calling in question, seeking a direction by issuance of a writ in the nature of mandamus, directing consideration of the representation in which the petitioner seeks release of seized 1531.25 quintals of rice and broken prior leather. The petitioner gets embroiled in a crime number 213 of 2014 for offences punishable under section 3 and 7 of the Essential Commodities Act, read with section 420 of the IPC. The police, after investigation, had filed a charge sheet. The concerned court tries the petitioner and acquits in terms of its order dated 10/1/2022, which has now become final. After the acquittal, the petitioner has submitted a representation. The representation is not considered. Therefore, the petitioner is before this court in the subject petition. The learned counsel, learned AGA, would submit that in the light of the acquittal, if reasonable time is granted, the representation would be considered and appropriate action would be taken in terms of the representation. The submission is placed on record. Therefore, they deem it appropriate to dispose the petition by directing the respondent to consider the representation dated 24/1/2024.
2, my lord.
24/1/2022 for the purpose for which it is submitted and take necessary action by passing necessary orders in accordance with law. The action taken shall be communicated to the petitioner. The aforesaid action shall be taken within 8 weeks from the date of receipt of the copy of this order, if not earlier. Please, ordered accordingly.
Okay. Gangadhar Jain, 20
The corporate society that state government. Yet, the expenses incurred for purchase of sugar cane that state as a department during the correct. Now, section 36, my lord, of the Income Tax Act was applied and the same was disallowed on the ground that only to the extent of SM, that is statutory minimum price, will be allowed. Now, my lord, thereafter, circulars were issued by the CBDT, my lord, relaxing this provision, saying that whatever the fair and remunerative price fixed by the state government will be applicable for the current assessment year, that is assessment year 16-17, my lord. This happened after the assessment order, my lord. Now, because of that, your lordship, I'll just draw your lordship's attention to those provisions, my lord.
What is under challenge?
My lord, application of the circular for the current assessment year is the main prayer, my lord, and consequently to redo the assessment.
My lord, they have raised additional grounds by filing an IA. Whether they would like to amend the petition is not.
Amended petition is already filed.
No, that is earlier round of amendment.
One more amendment.
One more amendment.
They want time, my lord. That's all.
Well, yes. I'm not saying that, but since you have filed, I'm asking, that's all.
Lord, the issue is very simple, my lord, that in view of the subsequent board circular, which is their own circular, my lord, of the superior, it is binding, that's all, my lord.
No, no,
So
we have
that
already, if I'm permitted, I can point out from the assessment order that what has been fixed by the state government, that has been allowed as a deduction.
Let the senior counsel finish. Yes, sir.
please go.
ಅಲ್ಲ ಅದೇನು ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕ್ಬೇಕಾ?
ಹಾಕ್ಬಿಡ್ತೀನಿ.
ಹಾಕ್ಬಿಡಿ ನಮ್ಗೆ ಒಳ್ಳೇದು.
Already 21 ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
Amendment you have filed or amended petition?
ನೋಡ amended application file.
Application has been filed.
Petition
Amend ಮಾಡ್ಬಿಡಿ. Will allow the application?
Your lordship can take a decision on that.
No, I am asking, you have objections or what?
No, at this point of time, we can, your lordship.
The petitioner has filed an application in IA number so and so, seeking to amend the petition. The learned, in the light of, for the reasons indicated in the affidavit accompanying the application and being satisfied with the same, the application stands allowed the petitioner to amend the petition and file an amended petition in the next 10 days. Interim order subsisting will continue till the disposal of the petition. I heard the learned senior counsel MB Sheshalant haki alla.
My lord, 59 I appear for the petitions. My lord.
Yes, sir.
My lord, this is a case of daily wages, 35 years they have worked. Jaggu case, para 32 of Jaggu case may be happening. In fact, I wanted to suggest your lordship, both in Dharwad and Bangalore, ಎಲ್ಲೆಲ್ಲಿದೆ ಎಲ್ಲ ಸೇರಿಸಿ ಒಂದೇ ಆರ್ಡರ್ ಬರ್ದ್ಬಿಡಿ ಅಂತ.
ಒಂದೇ
ಇಲ್ಲ, ಪ್ಯಾರಾ 22 ನಲ್ಲಿ has clearly said, if your lordship kindly see 22 to 25, it's a general directions.
It's a general direction, correct?
Yes, my lord.
Every citizen need not be asked to come to court for similar relief.
That is Colonel's case, my lord justice.
Yes, sir.
Your lordship may apply these two and close the case.
So even Shripal is there.
Yes, ma'am.
After Jaggu.
Yes,
there is a judgment after Jaggu.
Yes, my lord. Yes. In fact, I have sent all the compilations. Shripal is page 263.
Yes, sir.
We have filed our statement of objections.
Yes, sir. Everybody.
My lord, these are all class 4 employees and they are working as a cleaner, then cook, watchman, gangman, then my lord's Patakari. Class 4 employees. Page 19, the details have been given. So 1, 2, 3, 4, 5. 5 petitioners have retired, my lord. Petitioner number 6 to 11, except 9. Page 4, cast title. Petitioner number 6, 7, 8, 10 and 11 retired, my lords. As on the date of filing of the petition, 35 years, 39 years. In fact, there is one submission which I would like to make. In that Karnataka Daily Wages Act, my lords, adralli your lordships have already ruled that the basic pay and allowances in respect of the post held by them antide. That has been interpreted by my Lord Justice Sanjay Gowda in the Agriculture University, held that the posts are there.
Madam, you are ready, Allah?
Please.
No time. ಒಂದು ಕಾಂಪ್ರಹೆನ್ಸಿವ್ ಆರ್ಡರ್ ಬರೀಬೇಕು. ಫಾರೆಸ್ಟ್ ವಾಚರ್ ಇದು.
Pardon?
They are forest watchers?
No, no, no.
No, come to the petition, working as watchman,
Watchman, correct.
forest watcher and river watcher.
Patakari, then my lord,
Yeah, on record here.
watchman, gangman.
Watchman, patakari, gangman, cleaner, handsome, assistant, cooking man. Where is the order of appointment, sir?
No, no, it is true.
My lord, I have given a chart, my lord.
Chart is here.
Chart is here. Page 19.
You had approached this court earlier? Any one of you?
No, my lords, there is no. 2017 we have filed.
Where is any representation coming before this court, any of those orders?
My lord, representations, my lord, there are no representations except the page 72, my lords.
What is your objection, madam? You admit their employees?
Please, Your Lordship, admittedly they have been employed as after 1984, Your Lordship, and they are covered under Karnataka Daily Wage Employees Welfare Act, Your Lordship, and they are enjoying those benefits, Your Lordship. Hence, they are not admittable to regularization, Your Lordship. And I filed my detailed objections of page.
ಅದೇ ಡೀಟೇಲ್ಸ್ ಕಾಣ್ತಾ ಇಲ್ಲ, ನೋಡ್ತಾ ಇದ್ದೀನಿ.
ಇದೆ.
Page 72 to 82 is the representations.
And all the matters are not one and the same, Your Lordship. Every facts and circumstances are different, Your Lordship. Hence, they are not.
To forest watchers.
Yes, Your Lordship. And each.
Sir, I would need a chart or a synopsis of the date of entry, presently working, everything.
Yes.
So that we pass some order which becomes applicable to others.
Yes, my lord. Yes.
Because ಸುಮಾರು ಆರ್ಡರ್ ಹಾಕಿದ್ದೀರಾ ಇಲ್ಲಿ ಎಲ್ಲ ಇದೆ. I need something.
Please, my lord, please. I will do it personally.
I'll take it on Wednesday.
Please, my lord.
ಅಷ್ಟರಲ್ಲಿ ಹಾಕಿದ್ರೆ do something. Place the matter on Wednesday and preliminary hearing.
But if any connected matters are there, all that I am appealing to law. One
I will do
order.
that. That I will do, but there should be. I should have all the details here. If all the details are there, definitely I will do it.
ಈಗಲೂ ಬರ್ತಾರೆ ಫೈಲ್ ಮಾಡಿ ಬೇರೆ ಕೇಸ್ಗಳು ಕಾನ್ಸಂಟ್ರೇಟ್ ಮಾಡಕ್ಕಾಗತ್ತೆ.
ಅದಕ್ಕೆ we'll observe that also. Everybody need not be ಅಂತ.
Please.
But I need complete details of these cases.
Please.
Yes.
Number 60, Parshuram or?
May I seek some time, Your Lordship, in this matter, Your Lordship?
Early hearing.
We are formal party of the respondent number 2, my lord.
Who has filed early hearing, madam? No representation. We have the petitioner. List after 2 weeks. Yes.
Bill number 61, Gangadhar Jain.
Then, sir.
Lord, prosecution has been initiated. Lord, on the basis that the original return of income filed was false, my lord. Thereafter, a search took place. Based on the search, my lord, original return gets effaced. Only the subsequent return is there in existence, my lord. Based on that, my lord, assessment orders have been passed by way of a settlement commission. It is settled, my lord. Thereafter, once an order is passed, This honorable court has held that prosecution does not continue. It has to be quashed. Produced. I've served a copy on the other side also. Alle koಟ್ಟಿದ್ದೀನಿ. Please notice, my lord, at the ink page 30. Well, at ink page 30, my lord, prosecution under section 276C, 277. Once revised return is accepted, my lord, conclusion is that prosecution has to be quashed. Now, on the previous occasion, my lord, when the matter was argued, they raised an objection that this is not a revised return, but a return filed subsequent to search. Same thing happens even in the case of subsequent to search is at page 53, my lord. 60? 53, 53, my lord, of the paper book. Paper book, my lord. Your lordship may kindly go to the relevant portion at page 68, my lord.
68.
Yeah. My lord, 68, first sentence, my lord, the return filed under section 139 of the Act gets replaced by the return filed under section 153A(1) of the Act. Now, this, my lord, they are continued prosecution in respect of the original return, which is no longer there.
That's all the issue.
That is all the issue, my lord. Therefore, it has to be quashed. And the learned magistrate also does not apply himself, my lord.
Page?
Previous occasion, your lordship was pleased to notice it also, my lord, and noted in the order sheet. My lord, I have filed an amended application and produced it, my lord, at page amended application, annexure J, my lord.
So under what provisions you tell me?
Pardon, my lord?
Now, I have noted here, a fresh return was directed to be filed.
That is under section 153A, man.
153A, yes. So adadmele, the earlier return loses its significance.
Yes, sir, it loses its significance.
Yes, sir.
No, it is not like that, my lords. My learned senior counsel has simplified the whole thing. We will make our submission at 2:30. And
2:30.
Raviraj also will make a submission.
All right,
We'll have to take your lordship through various provisions of the Act to say that what
All right.
offense has been committed in the original return that doesn't get defaced. or
That's
it
all.
doesn't
That is all the issue. Yes.
Yes, it doesn't. The offense which has already been committed at in the original return will continue to be there, and the prosecution is on based on that.
All right. Yes. 2:30.
Number 62.
My lord, appearing to the petitioner in this matter, my lord, the petitioners are laborer, my lord, from Madhya Pradesh. They all belong to the scheduled tribe community. They were, my lord, brought here under bonded labor circumstances and made to work in fields in Nippani. Complaints were filed, my lord, by certain organizations saying that these workers, they have to be rescued from there. They are rescued, my lord, but unfortunately the DC at page 33, annexure A, he issues this report saying that this is not bonded labor. Admittedly, my lord, in this, that there was a 20,000 rupee advance paid on the head of each person who was brought here. And they were being made to work till they repay that entire amount. If my lord may please see page 34, at page 34, second paragraph, at the last 3 lines. Visited the place shown in the complaint on 21/2022 at 10:30. In all, 18 adults and 14 children were present. And on their being inquired, they told that the contractor Sham paid advance of rupees 20,000 per adult to work in the farm for cutting sugarcane. So, admittedly, my lord, they have advances given, they are brought over here. They are unable to come back, so they contact an organization which is in their my lord. This is at page 50.
So you sought that they should be considered as bonded laborers.
Yes, my lord, they were to be rescued, in fact. They had to
Now
be rescued.
they continue to be in Nippani?
Illa. They were rescued. They have now gone back to their villages. But my lord, this finding, this my lord is in the teeth of the definition of bonded labor at section 2G.
Yes.
My lord, my colleague is there. I have just on citations. I just want to bring on record.
Yes.
First, the Bonded Labor Act is right at the beginning, my lord, page 1. My lord, may please see page 2, section 2A. This is the bond.
Clifton.
Please, my lord.
What is the relief that you are seeking now?
Relief is, my lord, they'll have to be.
We'll quash this order, all right.
Yes.
But what becomes of it then?
What happens then, my lord? There is the union government, my lord, has come up with a scheme, a center. This is at page 85.
You tell me that.
Yes, my lord. Because unless this is complied with, my lord,
you tell me what's the use of quashing it? Yes.
That, my lord, if it gets quashed, then this scheme becomes applicable to them, and various benefits, my lord, under this scheme will be given to them.
Rehabilitation of bonded labor schemes.
Please.
Now they are rescued and they are sent back.
Please, my lord.
Where do you rehabilitate them?
My lord, this is something. This is not a peculiar situation, because this is what has happened across the country. That workers from various states. So this is not, in that sense, an unprecedented situation. The state government, my lord, will work it out with the union government and the Madhya Pradesh government on what can be provided to them.
Now, where is the evidence to show that they were paid and then kept as bonded labor?
That is admitted, my lord. That is not denied anywhere. Even in the what the DC says.
That's an admitted fact now.
Yes. That is admitted. Page 75
Is
is
it
the
place shown the complaint 18 adults, 14 children?
Page 75 is the Tahsildar
Contractor
report.
system paid advance of per adult to work in the farm for cutting sugarcane. ಯಾರು ಬರೋದೇ ಇಲ್ಲ. You will not get laborers.
And this, my lord, bonded
No,
labor.
the bonded labor should go away first. And what is the other form? See, bonded labor is only not paying advance. If you see under the Act, they should be controlled completely in their movement. They'll not let out food properly. All those things are there.
My lord, in fact, it's been subject to
This happens in plantations.
Yes, my lord. In fact, my lord, the Honorable Supreme Court, there are 3 judgments I brought on record in where the court has said, my lord, bonded labor is basically a form of forced labor. Now the old system, my lord, where you used to chain somebody, keep them there, that is gone.
No, not that. Those days are at least gone.
Yes. So now what they do is the kind of social control. My lord, I put myself in the feet of these workers. You have come from Madhya Pradesh. You're a tribal. You don't know the language. You are working.
We'll continue at 2:30.
2:30, my lord. Grateful, my
lord. See, it is listed. If you go on taking this, but again, nothing is happening.
My lord, for the last 2 years, this has been happening, my lord.
List the matter finally on Monday in the fresh matters list.
Tuesday,
event, no submission is made. In Tuesday, Becca.
Please, my lord. I'm traveling, my lord, on Monday.
Tuesday in the fresh matters list. As a last chance. Copy Kodia. Yes. There's an issue which needs to be answered. If somebody is getting benefit of that, let them.
Please. My lord. Next matter.
2:30.
Next matter. Only interim order extension now.
62.
63, my lord.
Vacating stay there.
Allah, 25 lakhs lordship has been imposed. 64 is covered, my lord.
64 I seek adjournment. Weeks accommodation lordship in the next
63,
week. 63, lordship, this honorable court put a condition that 25 lakhs I have paid. Deposit. I have filed 17 December 20.
Learned counsel submits that the interim order has been complied with.
That hearing,
in that light, the interim order shall continue to the next date of hearing.
Further orders were passed. The interim order ಮಾಡಿದೆ.
List on 20th, yes.
21st, my lord.
21st.
Much.
64 covered.
64 covered, my
Only
lord.
next week, Your Lordship.
Covered, madam. Refund of GST.
Royalty, my lord.
Royalty, Your Lordship. Royalty is a tax.
Supreme Court judge.
Next week, Your Lordship. Kindly.
Why?
list.
Covered andre close ಮಾಡಿ madam.
My lord, I have passed on the judgment, my lord.
Yesterday.
In same terms and conditions, it may be disposed of. Your lordship, conclusion, last page, last paragraph. Paragraph 23, my lord. Caption, capital E, conclusion, that's all. Same terms and conditions. It's in favor of the department, my lord, against the petitioner. And even connected matter also.
Other 64.1. Please, the learned counsel appearing for the petitioner, Kambi submits that the issue in the list stands answered by a 9-judge bench of the apex court in so and so. The conclusions that the 9-judge bench would draw are as follows. The learned counsel for the petitioner submits that the conclusions drawn are against the petitioner, and in all fairness would submit that the petitions be disposed in terms of the said conclusions. Counsel Chetna Viraj,
Please.
appearing for the respondent, would also toe the lines of the counsel for the petitioner. In that light, both these petitions stand disposed in the light of the aforequoted conclusion of the apex court in the 9-judge bench in the case of mineral developments.
Please, my lord.
Permitted to file my appearance in 64, Your Lordship,
Yavrali,
for
madam?
respondent number 1.
Yavrali?
64.
Counsel Chetna S. Viraj is permitted to file. You hakidira already, madam?
ಇಲ್ಲ
Have you
64.1 I have already filed.
64 ಅಲ್ಲಿ ಹಾಕಿದಿರಾ ಹಾಕ್ಬೇಕಾ?
R1.
Madam, ಹಾಕ್ಬೇಕಾ ವಕಾಲತ್ ಹಾಕ್ತೀರಾ?
Commercial, I have to file for R1
4
in
weeks time is
64.
granted to file power in favor of the second, favor of the
Respondent number 1.
and two in 64. Yes.
Please.
ಹೌದು ಮೇ ಸಿಕ್ ನೋಡ್ರಿ ಸೀರಿಯಲ್ ನಂಬರ್ 80 and 86 ನೋಡ್ರಿ ಮೇ ಸಿಕ್ ನೋಡಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನೋಡಿ
ಆಯ್ತು told, yeah, time
ನೋಡಿ
ಆಗ್ಬೇಕು.
86 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ
Put up, sir. Yes.
Serial number 98, my lord. Morning memo filed a memo for the covered by judgment, my lord. A light weight and motor. This 98 serial number. Kindly post it on along with those matters.
ಅವ್ರಿಗೆ ಕೇಳ್ಕೊಂಡ್ಬಿಡಿ.
Light motor.
ಅಲ್ಲ 80 ಅಲ್ಲಿ ಅವ್ರು ಏನೋ ಟೈಮ್ ಬೇಕಂತೆ ಇಟ್ ಇಸ್
ಅದರಲ್ಲಿ
ಇಲೆಕ್ಷನ್ ಆಗೋದಾಗಿದೆ ಇಟ್ ಈಸ್ ಓನ್ಲಿ ಫಾರ್ ಕೌಂಟಿಂಗ್ ಆಫ್ ದ ರಿಸಲ್ಟ್ಸ್ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ಜಸ್ಟಿಸ್
Justice
80
Shyam Prasad ಅವ್ರ
ಹೌದು ಅಲ್ಲ ಬಟ್
80
ಅಲ್ಲಿ ಅಷ್ಟೇ ಆಗ್ಬೇಕಾಗಿರೋದು ಬಟ್ ಅವ್ರಿಗೆ ಏನೋ ಟೈಮ್ ಬೇಕಂತೆ ಅಷ್ಟೇ ಅವ್ರ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೆಂಟ್ಸ್ ಹಾಕಿದ್ರು
80 ಅದೇ ಅಂದ್ರೆ ಕ್ಲೋಸ್ ಮಾಡೋಣ ಅಷ್ಟೇ.
ಫೈಲ್ಡ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡೋದು
ಅದಕ್ಕೆ?
ಸ್ಟೇಟಿಂಗ್ ದಟ್ ಒನ್ ಆಫ್ ದ ಪಿಟಿಷನರ್ ಇಸ್ ನಾಟ್ ಇಸ್ ದ ಡಿಫಾಲ್ಟರ್ನು
ಮಾಡಿ.
ಡಿಫಾಲ್ಟರ್ನು ರೂಲ್ 3 ಕಂಪ್ಲೈ ಆಗಬೇಕು
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನೋ ಮಧ್ಯಾಹ್ನ ಡೋಂಟ್ ಅಡ್ಜರ್ನ್ ದೋಸ್ ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಹೋಗ್ಲಿ ಸುಮ್ಮನೆ ಇಲ್ಲಿ ಪೆಂಡಿಂಗ್
ಅದು ಒಂದು ಬಿಟ್ಟು ಕೌಂಟ್ ಮಾಡಿದ್ರೆ
ಎಲ್ಲ ಅಲ್ಲೇ ಮಾಡಿ.
ರೂಲ್ 3 ಕಂಪ್ಲೈ ಆಗಿಲ್ಲ ಅದರಲ್ಲೂ ಕೂಡ
ನೆಕ್ಸ್ಟ್ ಅದಕ್ಕೆ ಟೈಮ್ ಕೇಳಿ ತಗೊಳ್ಳಿ ಮೇಡಮ್. Come to Dharwad list. One 2:30. Late ಆಗಿದೆ ಇದೆಲ್ಲ ಒಂದು ಕರೆದು ಬಿಡಿ.
230 board list, serial number 1, Asif M. Galgali.
My lords, the petitioner is the Mutawalli of Syed Mastan Dargah, Ballari district. He was removed as a Mutawalli without there being any inquiry. He challenged the said inquiry in writ appeal, and the first writ petition, it was a writ petition that was dismissed here. Then if preferred a writ appeal, they set aside the removal orders with the liberty to re-inquire the matter.
Order ಇದೆ.
Annexure C, your lords. As per Annexure F, there was an inquiry held and a report was also submitted, your lordship. And based on the report, board resolution was also passed. Now recently, as per Annexure K, he has got another notice for the same inquiry, your lordship.
What is the outcome of the earlier inquiry?
He was exonerated of the charge, your
Where is
lordship.
that?
Annexure F, your lordship.
Page.
Page number 41. Paragraph number 10.
On Mutawalli is presently discharging the functions. All right. What is exoneration here?
And this say, the said report was also
1 minute. Also, there are evidence to show how law and order was created during the Urus celebration. Work officer's allegation respect to misuse of family norms. This should be Mutawalli. In my opinion, we may independently see explanation. Where are you exonerated, sir? You are not exonerated.
they have not passed the specific orders, your lordship.
You are not exonerated.
After the report was submitted for perusal, in the board meeting, they have passed a resolution to that effect, your lordship. In page number 43, serial number 36, your lordship. In that board resolution, they have accepted the inquiry report of the inquiry officer.
Correct. Inquiry officer does not exonerate you at all. Notice correct ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ. Don't mistaken notion that inquiry officer has exonerated you. Anyway, serve on who appears for this? Work board.
Ladkhan, sir.
Ladkhan is directed to accept notice for both the respondents. Petitioner to serve set of papers upon the Ladkhan forthwith. List the matter on Tuesday in the fresh matters list.
Serial number 2, Vagish Ramnath Vigade.
Yes, my lord. How?
Voting rights.
Voting rights, my lord.
Yes.
Serial number 3, SD Kadatkatti.
Yes, ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ? ಇದು ನೋಡ್ತಾ ಇರಿ, ಪಾಸ್ ಓವರ್ ಮಾಡಿ ನೋಡಿ. ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಏನು ತಗೊಳ್ಳಂದ್ರೆ ತಗೊಂಡ್ಬಿಡಿ.
Serial number 4, Chetan T. Limbekai.
That's petitioner is a firm, my lords. For the assessment year 2019-20.
Why have you moved it for 2:30?
Let's demand notice is issued. Annexure.
When is demand notice issued?
12/1/2025.
12/1/2025.
Directing pay to my lords.
What is your ground? No jurisdiction?
No, my lord.
Why?
No, lord. Kindly see, my lords, page number 45, annexure D. My lords, senior geologist who has issued an endorsement stating that The petitioner firm has not carried out any business for the assessment year 2019-20. Let's kindly see, my lords. Despite of the same, my lords, the present, my lords, respond number 2, let's directed petitioner firm to, let's pay royalty amount to the government of rupees 2,31,000. Could be seen from, let's say,
TGA is directed to accept notice for the respondents. Petitioner relies upon an endorsement dated 21/12/2024 by which the geologist attached to the Mines and Minerals Department observes that for the years 2019-20, 2021, the business of the petitioner has been nil. Despite the same, royalties charged at 2,31,894 is the submission of the counsel to the petitioner. Therefore, there shall be an interim order of stay of further proceedings, interim order of stay as prayed for till the next date of hearing. One notice item. Next.
Objection is, my lords, seal is not forthcoming in the.
Of his objections overruled. Next.
Obliged.
Number 5, Ramchandra Mani.
Appear, my lord, for the petitioner. Petitioner, my lord, who was a temporary secretary of my lord, Cooperative Credit Society for the period between my lord 2011 to 2021. He has resigned. His resignation has been, my lord, accepted by the board. My lord, one member who had, my lord, fixed deposits with the society on default, my lord, submitted a complaint to the consumer forum.
The date of the complaint.
10/10, my lord,
10/10.
2021.
Heard the learned counsel appearing for the petitioner. The petitioner is said to have resigned from the post of the secretary on 21/2021. The same has been accepted by the society in terms of the board of the society, in terms of the resolution dated 4/3/2021. Long thereafter, i.e. on 9/10/2021, a deposit, an account holder who had fixed deposit in the society is said to have knocked at the doors of the Consumer Commission, which has resulted in the impugned proceedings. In the light of the aforesaid fact that the petitioner, as on 4/3/2021, by late, as on first date of the
Date is, my lord, 2/11/2020.
as on 21/2021 had nothing to do with the society. Therefore, there shall be an interim order of stay for the as spread for till the next date of hearing, emergent notice to the respondents.
May I seek hand delivery because warrant is issued and my lord.
Number 67.
ಇದರಲ್ಲಿ
Now, Bichigati, V.S. Santi.
Despite there being a specific direction, the lordship at writ appeal at page number 48, my lord, to consider my representation, that is to consider my candidature for the interview of the CWC, my lord. 48, my lord. The respondent number 3 has proceeded to pronounce the final list.
Yes, sir. CWC?
CWC.
Chairperson, CWC.
Please, my lord.
Who are you?
My lord, I was an aspirant for the post. I had applied, my lord. My candidature, although I was relatively much qualified, experienced, my lord, my candidature was not considered. Then I gave a representation which was not considered. Writ was preferred. There was an erroneous interpretation of the provision. My lord, writ appeal was preferred. My lord, wherein the honorable court at
Is
page
the order of
48.
single judge?
My lord,
Is order Akilva?
please, my lord.
Single judge is order Akilva.
Yes. Please. So that rule 15 was, my lord, interpreted.
Now what happened? Tell me.
My lord, despite there being a direction to consider my representation, that is for my interview, my lord, the final list has been announced by impugned notification at
The selection shall have to be proceeded in terms of notifications 14/7/22, 17/11/22. ಅದೇ ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಲ್ಲ ಅದೇ ಮಾಡಿದ್ದೀರಾ?
ಪ್ಲೀಸ್ ಅಲ್ಲ ಇವ್ರದ್ದು ನೋಟ್ಸ್ ವಾಟ್ ಹಿ ಕಂಟೆಂಡೆಡ್ ದಟ್ ನೋಟ್ಸ್ 2 terms it is not applicable for chairman, that is his contention. Notes the honorable division bench notes was pleased to hold that notes, and if the petitioner is otherwise eligible and qualified to appoint as a chairperson district child welfare committee Badari, consider his application for the said post along with the application of other persons and interview if he
So interview
falls within zone.
You did not.
Aurdu because of that condition that was 2 years, 2 terms.
Come to the rules.
Rules, my lord.
Yes,
Please.
rules.
Rule 15, my lord.
Writ petition
Which is
the rule has been
reproduced, my
extracted.
lord. Reproduced at page number.
There shall be one or more committee chairperson, so and so, so and so. A member of the committee shall be eligible for appointment for maximum of 2 terms, which shall not be continuous. ಈಗ ಎಷ್ಟು ಟರ್ಮ್ ಮಾಡಿದ್ದೀರಾ ನೀವು?
2 ಸಲ ಆಗಿದೆ, but not, no, continuous ಅಂತಿದೆ ಸಾಹೇಬ್ರೆ. It's not continuous.
ಯಾವಾಗ
Provision is very clear.
ಯಾವಾಗ ಆಗಿದೆ?
Once it was 2007 to 9, 7 to 10 as a member. 7 to 10 as a member and 14 to 17 as a chairperson. And the provision, my lord, rule 15, sub rule 4, my lord, is very specific on that, my lord. You kindly peruse the provision. That doesn't bar my, may I furnish the copy, my lord.
Yes, sir.
Also, there is a provision.
A member of the committee shall be eligible for appointment. The chairperson galva, appointment for 2 terms which shall not be continuous.
Continuous. And also there is a provision, my lord, that says nothing contained in sub rule shall be a bar in the case of a member being appointed as a chairperson. So my application is for the post of the chairperson.
Who becomes a chairperson? From mayor or from members?
Well, directly either application is for the
A member will
chairperson.
become a chairperson or somebody else?
Please, my lord.
A
No,
member
no,
will
my lord,
become
no,
a
no.
chairperson or somebody
direct-
else?
The provision is direct, there is an application either to the post of the member or to the post of the chairperson.
So one need not be a member to become a chairperson?
Not necessarily. It's not that among the member, one will be the chairperson, no. So directly, because the list is also hangge. Another chairperson list ಬೇರೆ ಇರ್ತದೆ, membership list ಬೇರೆ ಇರ್ತದೆ sir. So directly to the post of the chairperson.
Now you have, you are a member twice.
Once I was a member and once I was the chairperson. So I not at all a continuous, my lord.
When were you? I asked you, yes.
Between 7 to 10, I was a member, my lord.
2007 to?
10, I was a member.
Chairperson?
14 to 17.
4 years. 2 years.
ಆಮೇಲೆ?
And my lord, so far as my qualification, my lord, child rights, child welfare mele, relatively most qualified among the people who are applicants over here.
Where is the, who is selected now?
The respondent number, my lords, 4.
Respondent number 4 is appointed as a chairman.
When is the appointment ಆಗೋಗಿದೆ?
Appointment ಮಾಡಿದರೆ due to stay, my lords, they have not taken charge. ಯಾರ್ದು ತಗೊಂಡಿಲ್ಲ.
Because they have.
ಇದೆಯಾ ಇಲ್ಲಿ?
Stay ಇದೆ.
Selection list is been.
ಹೇಳಿ.
Lords, if at all he is eligible, my lords, it may be remitted back with direction that my lords will consider in his for interview. Because of the interim order, my lords, now the committee itself is not functioning, my lords.
Committee is not functioning.
Not functioning.
Because of the interim order.
Interim order.
Lord, my only submission.
Create a lot of problems, sir.
My only submission, my lord, interview career, if it appears that they are relatively more qualified than them, then I'll
No,
step
he
back.
is eligible.
Eligible. Already has, my lords, already has
relatively
done.
more.
He is not a member continuously for 2 terms.
2 terms.
Or chairperson ಏನು ಅದೇ ಇಲ್ಲ.
Lord,
Member and
past 20 years, my lord, I am absolutely into the child welfare. Child welfare ಮೇಲೆ PhD
Like
ಮಾಡಿದ್ದೀನಿ.
ಬೇರೆ
MA in
ಯಾವ್ದಾದ್ರು
psychology,
opportunity.
MA in child psychology. ಮನೆ 3 PG ಎಲ್ಲ ಇದರ entire life he has dedicated for the welfare of the
Continuing
child.
1 person to the same
Select
course.
ಮಾಡಲ್ಲ sir.
ಪೂರ್ತಿ ಸಾಹೇಬ್ರೆ ಅನಾಥ ಮಕ್ಕಳಿಗಾಗಿನೇ he is entirely has dedicated the life
Continuing,
for
my
this.
lords, same person to the same post, my lords, will
He has no other.
ಬೇರೆಯವರಿಗೆ
ಬೇರೆ ಏನೋ
opportunity
ಕೆಲ್ಸ
ಕೊಡ್ಬೇಕಂತ ಇದೆ.
There is no bar. Consider ಮಾಡಕ್ಕೇನಂತೆ?
Please.
ನನಗೇನು ಅವ್ರು ಎಲಿಜಿಬಲ್ ಇದಾರಂತ ಅವ್ರು ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ ಮುಗಿದೋಗಿರೋ ಸರ್. They are not even.
Petitioner is before this court, calling in question notification dated 30/10/2024 issued by the second respondent for the post of, for selection to the post of chairperson of Child Welfare Committee, the CWC, and has sought a consequential mandamus taking consideration of his representation for appointment. Heard so and so. Facts enumerated are as follows. The second respondent, second or third notification ಮಾಡಿದ್ದಾರೆ. The first respondent state issues a notification on 14/7/2022 calling for applications from eligible persons for the post of chairperson of the Child Welfare Committee. The petitioner, finding himself still eligible, files an application pursuant to the said notification. The second respondent then, on scrutiny of the applications, is said to have shortlisted the candidates of Ballari district and for the purpose of conduct of interview. The petitioner then submits a representation that to consider the petitioner, in the said shortlist, the name of the petitioner was not found. Therefore, the petitioner submitted a representation to the second respondent to consider his candidature for interview, which was not considered. He knocks at the doors of this court at that juncture in writ petition 1000656 of 2024. The learned single judge rejects the petition. The petitioner then files a writ appeal in WA 1000064 of 2024. The division bench sets aside the order of the learned single judge and issues a mandamus to consider the representation of the petitioner, and if he is found otherwise eligible and qualified to be appointed as a chairperson of the district CWC, consider his application along with application of other persons. If he would fall within the zone of consideration, he was directed to be interviewed as well. This having not been done, the petitioner is again at the doors of this court in the subject petition. This court, protecting the interest of the petitioner, has granted an interim order of stay, and therefore there is no selection process taken to its logical conclusion in the light of the interim order. The learned counsel appearing for the petitioner submits that the petitioner does not incur any ineligibility to be considered for the purpose of appointment to the post of chairperson of the CWC. It is a submission that the petitioner is the most qualified amongst any applicant therein, and therefore his candidature cannot be denied. The only impediment that is projected by the counsel for the state is that he is already a member for 2 terms of the CWC between 2007 to 2010 and 2010 to 2014. Therefore, his case cannot be considered is the submission of the learned AGA. Learned AGA. He would submit that the fourth respondent is chosen to be selected to the post of chairperson. In the light of the interim order granted and subsisting, there is no committee functioning as on today. Therefore, he would seek dismissal of the petition or a direction to appoint a committee, as it is causing grave disadvantage to the needy. The learned counsel,
And for the respond number 4, merits may also be considered because
Elradu consider madli, everybody, so and so. The learned counsel for the fourth respondent submits that the matter is yet to get concluded before the selection committee. The petitioner is before this court. Writ petition is premature. I have given my anxious consideration to submission so and so and so. The afore-narrated facts are not in dispute. The dates and link in the chain of events would require reiteration. The notification issued is on 14/7/2022, calling for applications for the post of chairperson, inter-alia. The post of chairperson, the post of chairperson and the qualification thereto is governed by section 15 or ruler.
Qualification 27, section 27.
Is governed by
27 section.
ಯಾವ rule ಇದು?
Section 27 of J Act for the
Is
qualification.
governed by section 27 of the Juvenile Justice Act 2015 and the rules framed thereunder. The rules framed thereunder, i.e. the Juvenile Justice Care Protection of Children Model Rules 2016. Rule 15 assumes the rule 15 is what is germane to be considered in the case at hand. It reads as follows. Rule 15 prohibits a person who has been appointed as a member, prohibits their appointment as a member if the said member has been chosen to be a member for 2 consecutive terms. The petitioner in the case at hand has been a member between 2007 to 2010 and between 2010 to 2014. Therefore, the petitioner has not been a member continuously as.
Second one is 14 to 17 as a chairperson.
14, and the petitioner has been on 14 to 17.
Second shift was 14 to 17 as a
7 to
chairperson.
10 a member, 14 to 17 chairperson. Therefore, the petitioner has been a member once and a chairperson once. The embargo under Rule 15 supra is a member being appointed twice over on a continuous basis. Both the condition that places an embargo is not applicable to the case of the petitioner at all, as the petitioner is neither appointed as a member continuously nor has been a member twice. He has been a member between 2007 to 2010 and chairperson from 2014 to 2017. Therefore, the candidature of the petitioner could not have been brushed aside, taking recourse to the aforesaid clause of Rule 15. The petitioner's candidature was to be considered along with others. The learned AGA submits that there is a stalemate as there is no committee functioning. Therefore, I deem it appropriate to direct the respondent, second respondent to redo the exercise of selection from the stage of scrutinizing of the applications, including the application of the petitioner and all other eligible persons who could come within the zone of consideration. And those persons shall be interviewed and the selection process shall be taken to its logical conclusion in consonance with law. 3 months. The aforesaid exercise shall get concluded within 6 weeks from the date of receipt of the copy of the order, if not earlier.
Please, grateful.
Sixty-eight adjourned. 69 case party.
My lord, return of court fee of deposit up by mistake, my lords. And section 67 of Karnataka court fee act.
Entitled for refund, the 67, entitled for.
Entitled for return.
Up amount
Correct
rupees
again.
67,000.
Noted.
They are filed. It is not taken. File is returned.
The file is returned for what purpose? You look into it.
To file Mullahs before the other forum.
We'll take it
Please.
on Monday. There are judgments.
Please.
Monday, madam.
Yes.
67, I'm aware. Yes.
70 admission matters. RM Javed, Sachin C. Kulkarni.
Anil Kale ಅವರು ಬಂದ್ರ ಶಿಲು ಅಂತ ಇದ್ರಲ್ಲಿ ಕಳೆ ಸರ್ ಅದನ್ನ ಸಿಲ್ ನಂಬರ್ 120 ಕವರ್ಡ್
Rejection of prosecution sanction.
ಅಲ್ಲ sanction is rejected. Against that, how can you come?
ತಮ್ಮದು ಒಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ.
ಅದನ್ನ
Subsequent ಇನ್ನೊಂದು ಬಂತು.
Contrary.
ನಟರಾಜ್ ಅವರು.
ಅದು ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ ಲಾರ್ಜರ್
ರೆಫರ್ ಮಾಡಿದ್ರು. ಆಮೇಲೆ your lordships, my lord, while allowing, my lord, the rejected, my lord, the case of the Lord Lokaयुಕ್ತ, on the ground that the T. Prakash case was relied.
ಹೌದು.
T. Prakash case ಅಲ್ಲಿ at that time, my lord, there is a stay by apex court. Now apex court has confirmed that order.
Which one?
T. Prakash case.
My order ಅದು.
ಅಲ್ಲ ತಮ್ಮ ಆರ್ಡರ್ ಅಲ್ಲಿ ತಾವೊಂದು ರಿಲೈ ಮಾಡಿದ್ರು. T.
Prakash. ಪ್ರಕಾಶ್ ಅಂತ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ.
ಪ್ರಕಾಶ್ ರೆಫರ್ ಮಾಡಿ. ಅದು there was a interim order of stay by the apex court. Division bench of this court in T. Prakash case was held that Lokaयुಕ್ತ has a locus.
Correct, correct.
Institutional interest and
Justice Satish Chandra Sharma.
ಸತೀಶ್ ಚಂದ್ರ ಜಜ್ಮೆಂಟ್. ಅದ್ರ ಮೇಲೆ ತಾವು ರಿಲೇ ಆಗಿದೆ.
ಆಯ್ತು, ಈಗ ಏನ್ ಮಾಡಿದೆ? ಕವರ್ಡ್ ಏನಲ್ಲ ಹಂಗಾರೆ.
ಅದು ಒಂದೇ ರೆಫರ್ ಮಾಡಿದ್ರೆ
ಹೇಳಿ, ಟೇಕ್ ಇಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಪ್ಲೀಸ್.
ಆಮೇಲೆ ಬಂದಾಗ ಹೇಳೋಣ. ಎಸ್, ಕಂಟಿನ್ಯೂ ವಿತ್ ದ ಲಿಸ್ಟ್. ಅಡ್ಮಿಷನ್ ಜಾವೇದ್.
Number 70, RM Javed, Sachin C. Kulkarni.
List on 21st. Interim order subsisting. Illa.
Remanded man. Is a remanded man.
Supreme Court.
Yes.
Oh, ನೀವು ಅಲ್ಲಿ ಹಿಯರ್ ಮಾಡಿಲ್ಲ ಅಂತ.
Yes.
ಇಲ್ಲಿ ಆಬ್ಸೆಂಟ್, ಅಲ್ಲಿ ಹಿಯರ್ ಮಾಡಿಲ್ಲ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗೋ ಬದಲು ಇಲ್ಲೇ ಬರ್ಬೋದಿತ್ತಲ್ಲ.
ಅಂದ್ರೆ complaint changed his address. He changed his address. And
changed his address.
Please.
Sir, you address the arguments now.
Please. I filed a statement of objections. There are 3 points, my lords.
Offense ಏನು?
Under Notaries Act.
He is the notary, is it?
He is a notary. He is a notary. He has been charged.
Notaries Act under section 14 applies.
Section 13 applies.
Well, section 14, the sanction is given for prosecution.
No, my lords, it is not there. And under Rule 13, if there is any misconduct on the part of a notary, the state government has to suo motu initiate action against him.
Section 14, no.
Rule 13, my lords.
Rule bidi. Rule is under this section. Go to section 14. Section 14 of the Notaries Act, without sanction from the state government, you can't initiate prosecution.
Please, my lords.
We'll dismiss it, Javed sir.
That was the earlier observation.
That was the observation. That
is the observation.
ನೀವು ಅಲ್ಲಿ ಹಿಯರ್ ಆಗಿಲ್ಲ ಅಂತ ವಾಪಸ್ ಕಳಿಸಿದ್ರೆ ಅಷ್ಟೇ, ಅದ್ ಬಿಟ್ಟು ಬೇರೆ ಏನಿಲ್ಲ ಇಲ್ಲಿ.
Looking to the facts of this case, when the acts of the notary are covered under the Notaries Act, then on this section would apply, my lords. My humble submission.
ಅಲ್ಲ, ಆ ತರ ನೀವು 197 19 sanction ಎಲ್ಲ ಅದೇ ತರ ಬರೋದು.
Please, my lords.
ಈಗ he has played fraud ಅಂದ್ರೆ it does not come within the discharge of duties as a notary ಅಂತ ಹೇಳ್ತೀರಾ ನೀವು.
Please, my lords. And it is not authentication or verification because he has.
Section 14 protection ಇದೆಯೋ ಇಲ್ವೋ?
He has purposely backdated.
Yes.
My lords, he has purposely backdated the document.
Who?
The notary.
Sanction ಕೊಡಿ, prosecution ಕೊಟ್ರೆ ಮಾಡಿಸಿ. I am not saying he can't be prosecuted at all.
Please, my lords.
I'll reserve liberty to approach the appropriate authority for sanction, which I had not reserved earlier. Now I'll do it.
Please.
No problem. The petitioner is before this court calling in question proceedings in CC 683 of 2015 registered for offences punishable under section 420, 511, 34 of the IPC. Heard so and so. This court by early order earlier order. Order ಎಲ್ಲಿ ನಾನು ಹೇಳಿದೆ? Old order. Earlier order ಎಲ್ಲಿ? ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ?
ಇದೆ.
ವಾಟ್ ಜಾವೇದ್, ಎಲ್ಲೋ ಹೋಗಿ ಬಂದ್ರ?
File at quotas.
ಮನೆಗೆ ಹೋಗಿದ್ರ?
ಇಲ್ಲ, file ಅಲ್ಲಿ quotas. It is there with me.
You should have all the material.
I had a copy.
Inadequate preparation ಅಂದ್ರೆ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. Get the order Monday. ನೀವೇ ತರಬೇಕಲ್ಲ.
Yes, ಇದೆ.
ಇಲ್ಲ ಮಾಡಿ ಕೊಡಿ ನೋಡಿ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಒಂದಿದೆ ಅಲ್ಲ. ಬಿಡಿ ಇಲ್ಲಿದೆ.
Sachin.
This court on an earlier occasion had disposed the subject petition by the following order. The petitioner was accused number 6. The complainant challenged said order before the apex court in Criminal Appeal 2927 of 2024. The apex court disposes the petition by the following order. The primary ground projected before the apex court by the complainant was that he was not heard in the matter. He was in fact served and had remained unrepresented for ages. The respondent complainant defends the said action on the score that the complainant had changed his address and would change his address. He would seek to submit that under Rule 13 of the Notaries Act, the petitioner, on Rule 13 of the Notaries Rules, the petitioner cannot be protected. The submission is noted only to be rejected. As Section 14, which this court had earlier relied on to quash the proceedings, clearly protects a notary from his acts and prosecution without appropriate sanction from the competent authority or / appropriate authority. The situation remains the same. However, I deem it appropriate to dispose the petition with a rider that it is open for the respondent complainant to seek sanction for prosecution as obtaining under Section 14 supra from the hands of the competent authority. The learned Sakalva.
Please, it should be.
Cognizance of offense under 13.
Huh?
Cognizance of offense.
Cognizance 13. Cognizance cannot be taken without sanction being placed before it. As simple as that. Yes. Court cognizance, sanction first. Sanction, so and so. In the event sanction is obtained from the hands of the competent authority, it is open for the concerned court to proceed with the proceedings against the petitioner. The aforesaid observations, the petitions, in the light of the aforesaid, the following order. Allowed, quashed with the aforesaid liberty.
Number 71, Mahajesh is here, ma'am. Suraj is Baloli.
ಬರ್ತಾರೆ adjournment ಹೋಗ್ತಾರೆ. Please note, petitioner notes, offenses are punishable under section 323, 324 and 354 of the IPC, my lords. Whereas, my lords, initially, my lord, the complaint is came to be registered against the 13 persons and accused number 1 to 4, they have been approached before this court, my lords. But column.
Your accused yaru? Present accused yaru?
1 to 4, my lords. There is no allegation against accused number 1 to 4.
The dispute is of civil nature, my lords.
Settled?
Yeah, yes.
Civil in this?
Civil nature. Civil dispute.
1 to 4, where the cost ಮಾಡಿದೆ ಎಲ್ಲಿದೆ? ಬೇರೆಯವರು ಕಾಸ್ಟ್ ಮಾಡಿದ್ಯಾ?
ಬೇರೆಯವರು ಕಾಸ್ಟ್ ಯಾರಿಗೆ ಮಾಡಿಲ್ಲ?
ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ, ಕಾಸ್ಟ್ ಯಾರಿಗೂ ಆಗಿಲ್ಲ.
ಇದೇನಿದು?
It has been withdrawn.
Interim order ilva?
Yes, there is an interim order, madam.
Page 20, 354 ಇದೆ.
Friday will pass. Next one. 21st.
Interim order.
Interim order will continue till the disposal of this petition.
72.
Obliged.
Vasudeva Naidu.
This is 21st.
73, 74 urgent, 75.
Adjournment, but 2074 withdrawal irodu.
75 MR Hiremata.
Steps to be taken in respect of R3. Who is R3?
R3 is the formal
to do the amount of subsisting will continue.
writ petition may be disposed of.
Sir?
As prayer sought by the petitioner already met out.
Already?
Already it has been over, my lord.
What is over in prayer?
That's referred a petition against
Petitioner
arrest
here
warrant.
Please.
Petitioners seeking here the arrest warrant issued by the trial court.
Arrest warrant?
Please, my lord.
Execution.
Annexed in the execution proceeding.
ಹೋಗಿದ್ಯಾ?
Prison ಹೋಗಿ ಬಂದು ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ಡೇ ಬಂದವಾಗ ಮತ್ತೆ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡೋದು. Very next day. The entire proceedings has been stayed, my lord.
Proceedings ಯಾಕೆ stay ಆಗಿದೆ?
Execution.
Execution ಮಾತ್ರ.
Execution.
Proceedings go on. Other proceedings with the direction. Why, what's the offense?
They issued the arrest warrant, my lord.
What's the offense under issued the arrest warrant?
Arrest warrant, there is no, the respondent has obtained the expert order before by the arbitration.
Will present.
Please, my lord. Thereafter, the petitioner appealed before the execution court and filed objection, my lord.
ಬಂದಿರೋದೇನಕ್ಕೆ? R3 ಯಾರು?
R3 is another one judgment.
Post immediately after steps to 2 weeks to do the needful. Next.
Request
Interim
my
order subsisting will continue to the next date of hearing.
Please, request my any date.
Correct ಆಗಿದೆ. Yes.
Please.
76 Ravi Hegde.
I for
RM
petition,
Javed.
Your Lordship. I personally served the copies for respondent 1 and 2 counsels.
Copy on whom, sir?
Respondent.
Prashant Usmani.
I 1 of 24. Your Lordship. Notice me kindly.
Madam, you are not there.
Please.
For R2, Your Lordship. For R2.
ಯಾರಿಗೆ ಮತ್ತೆ ಸ್ಟೆಪ್ಸ್ ಯಾರಿಗೆ?
ರೆಸ್ಪಾಂಡೆನ್ಸ್ ಐ ಎಮ್ ಎಲ್ ನೋಟಿಸ್ ಮಾಡಿದ್ರು ನಾವು ಪರ್ಸನಲಿ ಸರ್ವ್ ಮಾಡಿ ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಹಾಕಿದ್ದೀವಿ ಅಲಾಂಗ್ ವಿತ್ ಮೆಮೋ ಫೈಲ್ಡ್ ದ ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್.
Respondent. What's the matter, madam? ನೋಡಿದ್ದೀರಾ? ಏನು?
Please, it's a matter wherein the deceased employee has challenged his dismissal order before the labor court, Your Lordship, wherein the court has set aside the dismissal order and ordered for the 25% back wages. Agreed by that order, corporation had filed a writ petition again. The same has been dismissed, wherein the labor court has ordered to Your Lordship, the petitioners in the revision petition are the wife and the children of the deceased employee.
Yes.
25% of the 25% back wages has been given to the petitioners and 25% given to the R1, who is mother of the deceased employee. In revision petition, they are asking for the 75% has to be given to the petitioners, and remaining 25% has to be given to the R1, who is the mother of the deceased employee.
You are the wife and children idara?
Please.
Mother again, sir. How, what parameter did you give?
It's the labor court order, Your Lordship.
Labor court order. You have not challenged the labor court order?
I'm not ready, Your Lordship. Senior is out of station. So this may
Just
kindly
on
dispense with.
4th March. Yes.
Lordship notice may kindly dispense.
Notice, sir.
Dispense.
No. She is also entitled. If you seek modification of that, she'll be aggrieved. Yes. Next.
57 Mahesh Vadia, Shivsai M. Patil.
For the petitioner, but in the first petition, the petitioners are the accused number 3 and 4. Offense under section 499, 501, 502. The petitioners herein has initiated the proceedings against the complainant before the consumer forum because they have entrusted the construction of the house.
Again by the
ಎಲ್ಲ ಬೈದಲ್ they are defamation ಅಂತ ಹೇಳಿ ಇದನ್ನ ಹಾಕಿದ್ದಾರೆ because I will
defamation for legal proceedings.
Legal proceedings document number 3
ಮದುವೆ ದಿನ they have distributed the newspaper ಅಂತ
because
he filed defamation case. The builder, respondent is a builder.
Because the accused number 1 has published in his newspaper that is against the complainant.
It's the same crime.
Same.
Close this. The petitioner, accused number
3 and 4.
Accused 3 and 4 are at the doors of this court, calling in question proceedings in CC 3605 of 2021, registered for offense punishable under section 499, 501, read 501 and 34 of the IPC. You have accused?
You are accused number 5.
The accused number 5 and 6. Adalla. This petition close madradu yaradu?
Accused number 1.
ಇಬ್ಬರಿದ್ದಾರೆ.
ಇಲ್ಲ ಇದು page number 49 ಇಲ್ಲ.
CC 3605 ನಾವೇನು ನೋಡ್ಕೋಬೇಕಲ್ಲ. Same. This court, accused number 1 and 2 in criminal petition 101718 of 2021 had quashed the proceedings, holding that the statements allegedly to have been said to have been made would not constitute an offense under section 499 and 500 of the IPC. The petitioners accused 3 and 4, accused 3, 4 and 5 are entitled to the same benefit, same reasoning and benefit that is rendered accused number 1 and 2. This court has held as follows. Quote para 3 in the in the light of in the aforesaid light that shall in the aforesaid light the allowed cost. Connected both are. Connected ಅಲ್ಲಿ accused number 5, ಇದು 3 and 4. ನಾನು ಕಾಸ್ಟ್ ಮಾಡಿರೋದು 1 and 2.
78, V. Srinivas.
My lord, I
Lordship.
appear for petitioner in this case, my lord.
Lordship, I undertake to appear for Rajiv Gandhi Housing Corporation, Lordship.
My lord, in this case, I have called in question a notice issued which is at annexure N, my lord, page number 57. My lord,
Lordship, I pray for a short accommodation, Lordship. I may be permitted to file my wakalat and objections, Lordship. A very short accommodation, Lordship.
I have not been paid, my lord, I have not been paid salary since 5 years, my lord.
5 years?
Yes, my lord. From 2007 to till 17 to till now, I have not been paid salary on one or the other ground. They say, my lord, all over the state, my lord, all the CLTCs who are appointed along with me, 19 CLTs in the state, have been paid salary by the equal pay for equal wages by the deputy commissioner directly, my lord. Now, my lord, except to the petitioner, they are paying salary to, except for the petitioner, all of them are receiving the salary. So therefore, I am before this honorable court, my lord, except Belagavi, my lord. Belagavi wants me to take only on the basis of outsource basis. Whereas for the state, my lord, there is a direction by the managing director of Rajiv Gandhi Housing Cooperative Society.
All right, let the objections come. List the matter on 4th March. At the request of learned counsel Sumana Baliga, who seeks time to file power and file statement of objections thereon. In the light of said submission, list on 4th March, interim order subsisting will continue till the next date of hearing.
79, Adjournment.
My lord, petitioner is a retired employee, my lord, KSRTC employee. The office objection has been raised at serial number 18, my lord.
Office objections overruled. Yes, madam. Prashant Osmani.
Yes, ma'am. Please, ma'am.
Respondent. Provident fund ವಾಪಸ್ ಕೊಟ್ಟಿಲ್ಲ.
Yes, please, ma'am.
1, 2, 3, 4, 5. Shivraj Bullalli accepts notice. 6, 7, 8. Prashant Osmani accepts notice. The petitioner to serve set of papers upon the aforesaid counsel forthwith. 21st Kakirtini, close bound, retired employee. List on 21st in the fresh matters list. Ivatte copy kodi, madam.
Yeah, please, my lord. Much obliged, ma'am.
Number 80, Shreya Shanilopan.
Connected matter, my lord.
13D2A.
In connected matter, my lord, one of the petitioner is the defaulter. Not, he can't my lord, right to vote. The petitioner, my lord, not disclosed the two facts, obtained interim order and casted the vote. My lord.
I think Mukshi. Count it and let if she's aggrieved, like the petitioner is aggrieved, process not to law.
Submission maybe my lord recorded.
What submission?
The petitioner itself, my lord, playing fraud on the court, not the default. Kindly see my lord, page number.
Yes, madam.
54.
Why?
My lord, since
You Srinivas Naik or matter.
Namdal.
Srinivas Naik, second
In
matter.
connected
Matter.
petition.
Yes.
Review petition ಹಾಕಿದ್ದೀರಾ? ಅಲ್ಲ.
Serial number 80.
80.
80 and 80.1.
Rukmini Mahesh Patil. You are played fraud on the court ಅಂತ ಇದ್ದಾರೆ.
ಏನ್ ಫ್ರಾಡ್ ಇಲ್ಲ, ಡಿಫಾಲ್ಟರ್ಸ್
ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಡಿಫಾಲ್ಟರ್ಸ್ ಇದೆ, ರೂಲ್ 3 ಕಂಪ್ಲೈ ಆಗಿಲ್ಲ. That is not
ground ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, ground ಅಲ್ಲಿ para number 12 page.
But I filed an amendment for Lord petition also raising that ground. That is all subject matter of Lord dispute.
ground ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, they are not a defaulter ಅಂತ.
You contest. ಈ vote ಮಾಡಾಗಿದೆ. I will direct announcement of results. Anything you Shyam Prasad sahib order close ಮಾಡಿ.
I only request my submission may be recorded.
When fraud ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಅಲ್ಲ ಮತ್ತೆ fraud is the defaulter of not.
ಅಲ್ಲ, ನಾನು amendment, I have sought for amendment, additional grounds are raised, amendment petition is filed, raising rule 3 is not complied, and that is all subject matter of dispute.
ಅದೆಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ.
ಎಲ್ಲ dispute. All I will not record anything. ಸುಮ್ಮನೆ fraud ಅಂತೆಲ್ಲ ಬರೆಯೋದು ಬೇಡ.
ಅದರಲ್ಲಿ ಅದರಲ್ಲಿ ಸುಸ್ತಿ ಇದೆ.
ಅದು ಅಲ್ಲೇ ಅರ್ಜಿ ಮಾಡಿ. The petitioner is before this court seeking the following prayer. This court, in terms of its order at 19/12/2024, had permitted the petitioner to vote by the following order. Court made. The voting is over, the elections are over. What governs now is the order passed by the coordinate bench in VMS Vijayawada order. In the light of the said order, I deem it appropriate to, in the light of the said order, and while disposing the petition, I deem it appropriate to observe that all the contentions of both the parties shall remain open to be agitated before the appropriate forum, ordered accordingly.
Vote shall be considered and counted.
Considered and please, considered and counted.
87, 88, 89.
ಮೂರು ಅದೇನಾ?
ಆಮೇಲೆ
ಒಂದು ನಿಮಿಷ
143.
ಒಂದು ನಿಮಿಷ ಶ್ರೀನಿವಾಸ್.
87,
88.1 ಆಮೇಲೆ
ಅಲ್ಲ
87,
88, 89.
89 all same.
All same. 143, 144 is same. 105 ಅನ್ನು ಸೇಮ್. ಅವರೇನೋ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ದಾರೆ ಅದ್ರಲ್ಲಿ.
105 ಅದೇನಾ?
ಸೇಮ್.
Including application, my lord. I am contesting election.
ಅದರಲ್ಲಿ 13D2 ಗೆ ಕಂಪ್ಲೈನೇ ಆಗಿಲ್ಲ. 105 ಅಲ್ಲಿ ನೋಟಿಸೇ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ.
ಅದು ಅದೇನೆ.
Same.
105 also.
10 I have filed an application for impleading on the
You want
ground
to contest the matter here?
but my case is that they have challenged the legality of the disqualified ineligible on the ground they have not attended the two meetings, my lord. But the petitioners number 158, 159, that is not ground. They have taken the membership from within 1 year from the date of election. On that ground they have disqualified.
ಈಗ ಡಿಸ್ಕ್ವಾಲಿಫಿಕೇಶನ್ ಟೆಸ್ಟ್ ಮಾಡ್ಬೇಕಾ?
ಇಲ್ಲ ಡಿಸ್ಕ್ವಾಲಿಫಿಕೇಶನ್ ಏನಿಲ್ಲ.
105 ಇರ್ಲಿ ಬಿಡಿ. 105 ಬೇಡ, ಮಿಕ್ಕಿದೆಲ್ಲ ಬರ್ಕೊಂಡ್ರೆ ಮೇಡಮ್.
ಅಲ್ಲ ಡಿಸ್ಕ್ವಾಲಿಫಿಕೇಶನ್ ಏನಿಲ್ಲ ಅದರಲ್ಲಿ.
That's what he is saying.
Now votes have casted, petitioners have casted vote.
ಎಲ್ಲ ಅಲ್ಲೇ.
And admittedly, the secretary has issued a letter stating that Rule 13D2A is not complied with.
ಅವ್ರ ಪೆಟಿಷನ್ in terms of VMS.
ಹೌದು ಅಷ್ಟೇ.
ಸೇಮ್ ಆರ್ಡರ್. ಎಲೆಕ್ಷನ್ ಆಗಿ ವೋಟ್ಸ್ ಆದ್ಮೇಲೆ ಅದು ಎಲ್ಲ ಕೌಂಟ್ ಟುವರ್ಡ್ಸ್.
If he is aggrieved and he is a candidate in the election, what is his locus, my lord, to file an application in my petition?
Yes, the result
And he is anticipating that I have voted against these all petitioners have voted against him. How come?
My grievance is that I am the election candidate. The voting of the
contest, sir.
Voting of
contest.
Voting of this for
Not-
the
not
affect
in a
my
writ-
result, my lord.
Not in a writ proceeding. Yes. Next.
105 may be disposed.
Same, ಎಲ್ಲ.
Please. 143, 144 is also same.
ನಿಮ್ದಲ್ಲ.
ಅಲ್ಲ ಮಂಜುನಾಥ್ ಕರ್ಗನ್ ಅವರು ಸೇಮ್ ಆರ್ಡರ್.
143, 144 ಬರ್ಕೊಂಡ್ರೆ.
Please.
Sir, I may permitted to contest the in dispute, my lord, because my application is pending before this honorable.
Sir.
Pardon?
All impleading ಅದ್ರಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. 105 ಅಲ್ಲ?
105.
Counsel so and so submits that he has filed an impleading application. And
IA number 192, my lord.
In IA number 1 of 2025 and the same.
Two, my lord. IA number
192 of 2025 and would submit that the impleading application be allowed and he be permitted to come in as a party respondent to contest the matter. In the light of the petition being disposed, following the judgment of the coordinate bench, I deem it appropriate to direct or permit the impleading applicant also to contest the matter before the appropriate forum.
Yes. Obliged.
Forum. Ordered accordingly.
81 Arjan, 82 Sirajuddin Ahmad.
For the petitioner, my lords.
Two cases are
Corolla.
pending. Two cases are pending.
From 2019, that is 323 to 24, my lords.
What cases are pending?
323 to 24, my lords. And one case is 307, my lords.
ಯಾಕೆ ಆಚೆ ಹೋದಾಗ ಮಾಡಿರೋದಾ?
2000.
ಬರಲ್ಲ,
No, my
ಬರಲ್ಲ.
lords.
What?
No, my lords.
Bail ಇಲ್ವಾ ಅದ್ರಲ್ಲಿ?
No, my lords, they are not obtained.
Annexure B.
Trail ನಡೀತಿದೆ. Trail ನಡೀತಿದೆ, my lords.
List on 21st. Yes, next. ಇದು 83.
83.
83 minutes is this case of 5 years already. It is almost 7 years.
Sharad,
ಅಲ್ಲ
83.
ಇದರಲ್ಲಿ 30 days ಕೊಡು.
The petitioner is before this court seeking release of mother.
Yes, my lords, mother, my lords. Release of son, my lords.
The petitioner is the mother of a convict who gets convicted of an offence punishable under section 302 inter-alia by the court of session and is said to be in prison for the last 6 years and 4 months as depicted in the present certificate. The mother, first parole idu?
My lords, mother, my lords.
First parole.
First parole, my lords.
On such completion, an application is submitted by the mother before the prison authorities seeking grant of parole for a period of 30 days, a period of 90 days. The same is not considered, therefore the petitioner is before this court seeking a direction for release of her son on grant of parole. The learned counsel submits that the petitioner is now the learned counsel for the petitioner submits that the mother has not seen the son for the last 6 years and 5 months that he has been in prison and has not been released on parole even once. In that light, I deem it appropriate. In that light, as also the fact that there is no adverse entry made against the petitioner in the prison as found in the custody certificate, I deem it appropriate to grant the petitioner parole for a period of 30 days.
My lord, 60 days.
Extension period of 30 days. So with liberty to seek extension of parole owing to the.
May I make a request? Let them ask my lords to send a uplist application. Police report telludre bartane illa.
So and so. The Sirajuddin, henceforth I will stop granting parole.
Yes,
If you don't give the application to the jail authorities and a report is not there, I am not going to grant parole.
My lords, first
Yes, sir.
Yes, my lords, I am following.
What, yes?
All the prisoners are submitting the applications, my lords.
Where?
But, my lords, that will not be forwarded to us, my lords, advocates, my lords. It will take 2 months, 3 months, my lords. Emergency parole idreno application agidmele they are not ready to provide an application. Advocate geli mail haki antara. If we file a mail also, then the submission of the state is that the advocate is filing a mail anta helbiಟ್ಟು.
ಅಲ್ಲ ಕೆಲವೊಂದು ಕೇಸ್ದಲ್ಲಿ ಅವರು they are sending
subject to conditions.
In other cases, my lords, they used to send ಇಲ್ಲ through post ಕಳಿಸ್ತಾ ಇದ್ದಾರೆ. ಅದ family members through post ಕಳಿಸ್ತಾ ಇದ್ದಾರೆ.
ನೀವು ಮಾಡಲ್ಲ.
Form 9 ತಗೊಳ್ಳೋಕ್ಕೋಸ್ಕರ they will not accept, my lords, very easily. So that is the reason the family member, the petitioner is held.
हो गया अब. Yes.
That's 60 days, my lords.
Extension subject.
Okay. That's on submission with 150 and 153, my lords, already office subjections has been complied.
Ad barli wait. Yes.
Apply.
Petitioner seeking writ of mandamus to directing the respondents.
84.
The names in the eligible voters list.
Votes casted, your lordship, and
Similar matter
order
has
to
been
be
disposed
announced,
of,
your
your
lordship.
lordship,
Results, sir.
Against the same society.
ಕೊಡಿ just ಅನಂತ ಕಡೆ ಅವ್ರು follow ಮಾಡಿ. ಅದೇ what?
Results are announced, your lordship.
Results already announced.
Yes, your lordship. Order to be announced, your lordship. I don't.
Order to be.
It has not been announced.
Result forthwith, including the votes cast by the petitioners. All conditions left open. Same.
Order ಆಗಿದೆ ಅನೌನ್ಸ್ ಮಾಡಕ್ಕೆ ಅವ್ರು ಮಾಡಿದಾರೆ ಇಲ್ಲ
ನೋಡಿ ಕೊಟ್ಬಿಡಿ
order
Copy
to
has
be
been
announced.
served.
Yes, next. Same order ಮಾಡಿ. ಅಂದ.
Grateful.
85, Pratik.
Appear for petitioner in this.
Submission. Court on 29/1/2025 had passed the following order. The learned counsel for the petitioner submits that he has no instructions with regard to payment made or otherwise. Madidara? The counsel for the respondent bank submits that not even a rupee has been paid pursuant to the order dated 29/1/2025. Therefore, there can be no indulgence shown to the petition in the light of the observations made in the order dated 29/1/2025. The petition stands rejected. Interim order stands dissolved.
92, Sangram S. Kulkarni.
My lord, the respondent number 2 had filed an application under section 44.
Office objection in, sir.
My lord, there are other authorities to whom the order of the copy of the order has been sent, my lord. I have not made them as parties to the present.
Office objections overruled. List on Monday in the fresh matters.
My lord, I am seeking interim urgency.
Yeah, urgency.
My lord, they have directed to attach the properties, my lord, and they are another direction which has been given is that we have to execute Mutawalli, that is a promissory note, my lord, and also a direction as
on Tuesday in the fresh matters list. Learned AGA is directed to accept notice for the first respondent, emergent notice to the second. The second respondent be served by way of hand summons. Wednesday in the fresh matters list, status quo, the property be maintained till the next date of hearing.
93, VP Badbi.
Here, my lords, the petitioner, my lords, has applied for the post of village rehabilitation workers, my lords.
Village?
Rehabilitation workers. That came to be, my lords, my application came to be rejected on the ground that another petitioner by naming the respondent number 4, he is having less disability, my lords, considered
less visibility.
Disability certificate.
Disability.
Please, my lords. And having more marks in the SLC marks card. But the conditions, my lords, the regulations at page
Anyway,
number 1.
take notice. Learned HCGP is directed to accept notice for 1, 2, 3.
1 and 2
notice.
only, your lordship.
Huh?
1 and 2, your lordship.
Oh, Taluk Executive Law. 1 and 2 are 3 and 4 emergent notice returnable by 7th.
May I seek for early?
Prayer, interim prayer.
Please. That's on 25th. I will take chance.
26th, 25th, yes.
25th.
25th.
Great.
Returnable by 25th.
In fresh matters.
Returnable by 25th.
Please.
54, Shivani Shetty.
The office objections regarding few annexures, my lord, we are not relying on it. We made a council submission.
Who are you?
My lords, I am the chief accounts officer. I was the chief accounts officer at the relevant point in time in respondent number 3 organization. One, Mr. Deepak, he creates fictitious vouchers, and on the basis of fictitious vouchers, he gets certain bills cleared insofar as the contractors are concerned. My lords, may I kindly see that I have produced the charge sheet. Charge sheet is filed against only Deepak, and I am named as a witness in that. My lords, the only ground which I am urging today, my lords, is regarding non-compliance of Rule 36 of the allocation of business rules, my lord, because they are required to take the sanction of the Honorable Chief Minister before.
Why?
My lords, may I just pass on record the transaction of business?
Could he? Chief Minister will not be.
Insofar as a grade A, I'm a senior grade A officer. So far as I am concerned, my lords, under Rule 30, may I just pass this on?
Rule 36, right?
36 minutes. Page number 12.
Yeah, yes.
All cases of this nature specified in the second schedule shall be before the issuance of orders thereon be submitted to the Chief Minister by the Secretary of the Department through the Minister. My lords, if my lords were to see schedule 2, serial number 8, my lords, cases relating to disciplinary inquiries against an official equivalent to the rank of the official in the Karnataka Administrative Service Group A senior scale and above.
Now, what is you're challenging a show cause notice?
I'm challenging a show cause notice, my lords.
That show cause notice is given 6 months ago.
No, my lords, it's given in September. Only the show cause notice given, no annexures are given. I write a letter to them, they give me the documents in December. My lords, may I kindly see paragraph 21. I've explained what exactly.
But then what has happened today?
My lords, as on today, my lords, I have not given they have given me the documents, my lord. I have sought for time because I had to obtain the charge sheet. My lords, may just see the charge sheet at page 261 for a minute.
Charge sheet on the criminal side or this?
Charge sheet against Deepak. Let me just explain. 1 minute.
1 minute. In Deepak is now charge sheeted both criminal in the criminal proceedings also.
Criminal proceedings.
Oh.
And I am named as a witness saying that he has breached my trust. He has produced, may I just request my lord to kindly see page 261 for a minute. 261 if my lords have, my lords.
One moment.
Second paragraph. ನಂತರ ಅಧಿಕಾರಿಗಳು ಕೆಲಸದ ಒತ್ತಡದಲ್ಲಿರುವಾಗ ಸಂದರ್ಭದಲ್ಲಿ ಬಳಸಿಕೊಂಡು ತಾನು ಸೃಷ್ಟಿಸಿರುವ ಬಿಲ್ ವೌಚರ್ಗಳನ್ನು ಒಂದನೇ ಆರೋಪಿಯಾದ ಗುತ್ತಿಗೆ
No, the whole problem is that it is only a show cause notice unless it is without jurisdiction.
It is without jurisdiction. I am saying that it is.
That you should.
My lords.
How do you demonstrate that?
My lords, insofar as Rule 36 is concerned, my lords, in a similar, insofar as my suspension is concerned, my suspension was also set aside on the ground that Rule 36 was not followed. My lords, I'll just pass that judgment.
Heard the learned counsel Ajay Nandalike appearing for the petitioner.
I just have one submission. Sorry. If my lords were to just call for to see whether Rule 36 is.
Exactly. Right? Yes. Ajay Nandalike appearing for the petitioner. The petitioner is said to be the chief accounts officer, an officer in Group A. According to the learned counsel, if proceedings are to be instituted against him, it should be only after the prior approval of the chief minister. He would seek to place reliance upon Rule 36 of the Transaction of Business Rules to demonstrate that for a Group A officer, it is the chief minister whose prior approval would be required for any initiation of prosecution or a departmental inquiry, as the case would be. The learned counsel would further take this code through the crime registered against Deepak A. Mudalgi, who has perpetrated the allegations in using the name of the petitioner. The petitioner is said to be a witness in the crime registered against Deepak A. Mudalgi. The learned counsel would further submit that order of suspension was challenged before this court only on the score that the Rule 36 of the Transaction of Business Rules noted supra was not followed. With all these circumstances, I deem it appropriate to grant further stay of the notice and all further proceedings taken thereto till the next date of hearing. The learned HCGP shall place on record the records with regard to the matter being placed before the chief minister prior to the issuance of the show cause notice by the next date of hearing, list the matter on 21st. Madam, our time kelbedi.
Please. Regarding e matter, serial number 95, HR Kambiar.
Appear for the petitioner, my lords. I have filed application for
Recalling.
recalling the order dated 21/2020.
On prosecution.
Non-prosecution.
In order, putting.
Further order under section 69.
Dismiss for non-prosecution. Nanda. Oh, even today, no, 2012 matter. Yes. Again.
After the dismissal for non-prosecution, further DNP ಆದ್ಮೇಲೆ the procedure further and passed order under section 69(1). After the dismissal of the petition for non-prosecution.
ಆಗ್ಲೇ ಮಾಡ್ಬಿಟ್ರಾ?
ಅಲ್ಲ, old matter ಇದು pending ಇಟ್ಟು.
Yes, sir. You don't appear. ಏನ್ ಮಾಡೋದು?
They have to challenge this order.
Annexure A has been challenged. Annexure A is also on to challenge, my lord.
ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರೆ ಆರ್ಡರ್. We will recall this, restore the petition to file and dispose it, reserving liberty to challenge this. The subject petition comes to be dismissed for its non-prosecution by the following order. Page 3. Counsel for the petitioner has filed an application seeking a recall of the said order for the reasons indicated in the affidavit accompanying the application, and being satisfied with the same, the order dated so and so stands recalled. Petition is restored to file. Next paragraph. The learned AGA on instructions and securing of records would submit that after the dismissal of the petition as afore quoted, the competent authority has passed an order. The learned counsel for the petitioner at this juncture seeks leave of this court to challenge the said order. In the light of the petition restoring in the light of the aforesaid circumstance, reserving liberty to the petitioner to challenge the order dated 11/2/2025, the petition stands disposed.
Petition is pending.
Huh?
The petition is pending.
No, no, challenge it. Ella serisi challenge ಮಾಡಿ. Next.
96, Sunil is Desai. Desai and Patil.
Statement of
Shivsai Patil. Learned Counsel Shivsai Patil seeks 2 weeks time to file statement of objections.
Next week, Lord, take a chance.
ಎಷ್ಟೊಂದು ಪಾಯಿಂಟ್ wait ತುಂಬಾ ಆಗೋಗ್ಬಿಡುತ್ತೆ. So many
Interim order.
pending there.
Interim order may kindly be extended.
Interim order ilva? That will continue. Interim order will continue till the disposal of the petition. But our objection till the next date of hearing.
97, Prashant.
Petition lords was dismissed for non-prosecution because of non-compliance of office objections. Weeks time, lords, I'll comply with the office objections.
Not mine, sir. I thought I have done it.
No. In fact, sufficient time was given, lords. My fault.
For the reasons indicated in the affidavit accompanying the application, being satisfied with the same, the order date so and so stands recalled. The petition is restored to file subject to condition that the petitioner would comply with the office objections in the next 1 week.
Please.
If the objections are complied with by the 21st, list the matter in the fresh matters list on 21st.
Okay.
99, Anandar Koldi. 98, Adjournment. 99, Anandar Koldi.
Lordship, this matter has to be listed before the quota number 4.
Howda? Registry to registry. SKSRTC na. GML. Counsel for the petitioner submits that the matter has to be listed before the bench of Honorable Justice Suraj Govindraj. List the matter. The registry is directed to list the matter accordingly. Next.
Not one, HR Kambiavar. Suraj is Balwadi.
There is filed, but that may not survive, my lords, because the
which one?
The IA for additional prayer during the pendency of, my lords, the interim order, without noticing the interim order, my lords, the original order in original was passed. That has now been withdrawn, my lords, by the commissioner. It has also been communicated.
I have filed 2 IAs, my lord. IA for 1 is additional document and IA for 2 is additional prayer, my lord. During the pendency, they was order was operating. They passed the order.
They withdrawn.
I have withdrawn it. Communicated.
Withdrawn ಮಾಡಿದ್ರು.
Petition ಉಳಿದಿದೆ, IA ಉಳಿಲಿಕ್ಕಿಲ್ಲ.
My lord, here legal question has been primary.
Petition ಅಲ್ಲಿ ತೀರ್ಮಾನ ಮಾಡೋಣ. IA
Please.
Learned Counsel Shivraj Bulali submits that the application filed for direction or additional prayer would not survive for the reason that on a mistaken notion and without noticing the subsistence of the interim order, the assessing officer had passed an order. On realizing that the interim order is in subsistence, the order has since been withdrawn. The said submission is placed on record. Therefore, it is unnecessary to consider IA 1 of 2025. It is disposed as having disposed as having become unnecessary. The main matter will be on the date.
Please. Both IAs may be.
Both IAs.
Please. And interim order may be extended.
Interim order subsisting will stand extended till the next date of hearing, first week of March.
Obliged.
Objections if any.
Filed, already filed.
Filed.
Please.
The last one, but next.
Obliged.
Yes.
Matpati. Venkatesh Matpati.
First matter I'm appearing.
In this I seek permission of this honorable court to appear on behalf of the petitioner, my lord.
Yes,
both,
sir.
He will argue both in both petitions. In another matter. ಎರಡು matter ಇದೆ, ಎರಡು same. ಎರಡು ಸೇಮ್ ಆಗುತ್ತೆ. ಅವರು ಅವರಿಗೆ ಒಂದು ಮಾಡಿದ್ರೆ.
Yes, sir.
Volume ಜಾಸ್ತಿ ಇದೆ.
My lords, the question involved in this case is the de-recognition of the IAM, which has been granted in favor of the petitioner, is being challenged. The impugned order is at Annexure T page number 197. Short point, my lords, I intended to place it immediately.
The amendment application is pending. If that is allowed, I'll file detailed objections to in the connected matter.
no?
Second matter, the amendment application has to be allowed.
My lords, with
Yes, sir.
My lords, with respect to the objections or the statement made by the respondent is concerned, I make a small submission. My lord may kindly see the order sheet from 28/11/2024 on the same ground. On the same ground of filing the objections, the matter is being adjourned, and I should not say these words, but for the best reasons known to the other side, they intended to postpone the filing the objections.
I
My
objection
only
ಆಗ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದೆ.
contention,
I said now application can be allowed. I'll file detailed objections to the main matter itself. I did not. I sought time to file objections to IA.
He is for the first time notified on 19/11/2024. And next time he has sought time once on 28/11/24 and again before me on 13/1/25. Ashte.
Allah.
He is entitled for 2 or 3 more.
10,594.
No, I'll file objection. I'm not saying.
He is entitled for 2 or 3 more.
My lords, by your adjournment, he has taken it. No, granting by your adjournment, they have taken it. If my lord could kindly fix up the date between 19 to 21, on that day I shall come and make my submission and take the
20.
Yes, I'm. Yes.
Allow ಮಾಡಂತಿರಲ್ಲ. You are saying allow the amendment.
Allow ಮಾಡೋದಾದ್ರೆ ನೀವು objection ಹಾಕ್ಬೇಕಾಗ್ತದೆ.
No, IA may be allowed. I'll file objections to the main petition itself.
ಅಷ್ಟೊಳಗೆ ಹಾಕ್ತೀರಾ?
Yes, no. If IA is allowed and for copies,
What is the IA, sir?
I am not second distance certificate issued, which I did not notice. Therefore, after filing writ petition, when I obtained a stay order, they must the response submitted another distance certificate which is subsequently issued. That is challenged before us.
Then we'll allow the IA.
This is our
IA number.
For me, I should argue the matter. I have argued the matter in the year 2020, 5/2/2021. Authority keeps quiet for 3 years, and all of a sudden it passes an order. So many developments has taken place. Therefore, my lords, my
I came only in
only
2024.
submission is, if some time is granted, my lords, I'll only ask this much. Kindly give him a time till 19th.
All right. IA
Please.
allow ಮಾಡೋಣ.
Yes.
The IA on order on IA 1 na 2 na 3 na 4 ಏನದು?
1 of 2024.
IA 1 of 2024. For the reasons indicated in the affidavit accompanying the application being satisfied with the same, the application stands allowed. The learned counsel Mallikarjun Swami Hiremat to file statement of objections. ಯಾವತ್ತು 27ಕ್ಕೆ ಹಾಕೋಣ?
Any shorter date, because I have to get the bank guarantee renewed. The banks are not renewing them unless there is order from the court.
This 25th.
Because in case the amount was
25
My lords, it is in a hanging position. It is in the hanging position. The bank has sent, honored the bank guarantee. The department has not encashed it. We are in that stage, but they are charging interest of 2.5 lakhs rupees per month.
List on 25th.
Please.
meantime, my lords, we file
My
objection.
lords,
Amount was encashed.
before 21st or first week, my
ಯಾವತ್ತು
lords,
ಬೇಕು ಸರ್? When do you
instead of
want?
25th,
When
my
do you
lords,
want it?
before 21st or first week of March, my lords.
First week of March.
Last week I'm trying for Kumbh. Let me try my luck.
Prayagraj.
Prayagraj.
ಆಯ್ತು ಸರ್.
Last week I intend to try.
ಆಯ್ತು ಸರ್.
IA number 2.
ನೀವು ಹೋಗ್ತಾ ಇದ್ದೀರಾ?
24. No. IA number 2.
2 of
2 of 2025. Yes. 7th March, sorry, 6th March.
Obliged.
Not for adjournment, 106, Suresh Kundi.
serial number 1 not.
Serial number 100.
Adjournment ತಗೊಂಡಿದ್ದಾರೆ ಗೊತ್ತಿಲ್ಲ.
Adjourn. Senior counsel has been engaged, my lords.
ಯಾವ್ದ್ರಲ್ಲಿ?
See, 103, my lord. Senior counsel is appearing through VC, my lords.
Who senior counsel? Dharwad case ಅಲ್ಲ?
104 number.
Friday problem.
Not 6.
106, my lords, I appear for the petitioner. My lord, senior advocate Shri S.S. Ramdas is briefed in this matter. My lord, he had to undertake travel to Prayagraj. My lord, a request for a short date next week, Friday. My lord, we are ready to address
My lord,
arguments on merits. My lord.
It may be listed on Monday, my lord. Because just now they have served with the copy of objections to IA filed by me, and the circular is just now furnished. Maybe on call on Monday.
Okay. We'll have it on 3rd March.
No, madam. Monday, please.
Day after tomorrow.
Yes.
That's difficult. Yes. Yes, sir.
Lord, day after tomorrow.
Monday. Yes.
Please, my lord, the interim order may kindly be extended.
Interim order subsisting will continue to the next date of hearing.
If my lords may kindly call it next Friday, my lord, I request instead of Monday, my lord.
Council has objections, sir. Friday
Please,
The matter is urgent, my lord. Monday only.
Monday. Monday ಬಿಟ್ಟು ಬೇರೆ ಏನು ಹೇಳ್ತಾನೆ ಇಲ್ಲ ಅವರು. Only Monday. Yes.
Please, my lord.
107. Or Nagendra Naik?
My lord, we are representing the petitioner, my lord.
Yes, my lord. Being one of the officers association of the respondent number 1 bank, I have filed application for implementing me as a party respondent number 2, my lord. Because I am the officers association having majority after the introduction of the new HRMS system, my lord. They have challenged the very introduction of the HRMS system. So, since I am representing the majority of the employees, I may be permitted to contest in this matter, my lord.
My lord, we have to file objections
I
for
am the
this.
union having majority now.
What is HRMS?
Human Resource Management System. Andre modlu the for check off facility and salary and all, it was manual. Now it is purely computerized, and they have challenged this, saying that it is not
Objections, Saki.
Yes, I need to file. Yes.
You want to file objections to the implementing application?
Yes, my lord, we want to file file objections, and we will be physically present and argue on 20th.
All
Our
right.
petition.
No 20th objection. Aki.
Our petition.
Oh, stay idea.
Yes, my lord.
Yes,
That's
How can
why.
this be
There is
stayed?
no stay, my lord.
No, there is a stay. How can check off mandate be stayed, sir? No.
No, it is not stayed, my lord. They have your
Only
inspection
with
only.
regard to check off mandate till the next date of hearing.
Yes, my lord.
How that causes serious prejudice to the employees.
Yes, my
No,
lord.
sir. How did it take stay of check off system?
Actually, our prayer was not for
That too,
stay.
they have abided by the said system, my lord, for the month of September, October, November. When in the month of
Nagbhushan
December,
Rao ಅವರೇ,
Yes, sir. Yes, my lord.
ನಿಮಗೆ ಇದು ಸ್ಟೇ ತಗೋಬಾರ್ದು ಅಂತ ಗೊತ್ತಿಲ್ವಾ?
ಅಲ್ಲಿ ಗೊತ್ತಿದೆ ನಾವು ಸ್ಟೇ
ಮತ್ತೆ?
ಕೇಳೇ ಇಲ್ಲ. We have not prayed stay. Actually, original earlier
ಸ್ಟೇ ಇದೆ,
circular,
ಸ್ಟೇ ಇದೆ ಇಲ್ಲಿ.
there is no prayer for stay.
ಅಲ್ಲ
No
14
prayer.
ಇಲ್ಲಿ ಕೊಟ್ಟಿದೆ. 18/12/2024 interim orders.
That is what I'm saying.
Yes.
18/12/2024, there shall be stay of the operation of circular.
yes, my lord.
No, that circular should be continued. That was our prayer. Until this HRMS is streamlined.
It may be vacated, my lord.
Then I will modify the interim order.
Yes,
Yes,
my
my
lord.
lord.
The learned counsel appearing for the petitioner submits that the stay of the operation of the circular would cause prejudice even to them. Therefore, the interim order, the indication in the interim order of indicating stay of circulars dated 14/5/2024 and 38/2024 stands modified or stands modified.
Modified.
Vacated on Mavadi. Yes.
Modified and the
Stands vacated.
yes, my lord. Yes, ma'am. Much of it.
108. RM Javed.
Yes, faculty members, my lord. Day before yesterday, which was all the matters pertaining.
Same, madam, guest lecturers on the order ಮಾಡಿದ್ದಾರೆ. Same order.
Sir, petition copy.
Interim order is there.
Same order.
109. Adjourn. 110.
110, my lords. I seek my lords apology. Lordship has directed me to secure entire charge sheet.
Pertains to
I'm
the
sorry.
architect, my lords.
You did not go back.
No, my lords. We were really even expecting that disproportionate asset matters. Probably it's gone to 7th, I
So
think.
you were informed, right?
I was.
Yes.
But anyway,
told
I
you
had
to inform you that.
Yes.
Won't be.
My lords, this was a matter where my lords quashed the proceedings to, so far as accused number 6, my lords. My lords was under the impression A6 was the architect and quashed the proceedings.
ಗೊತ್ತಾಯ್ತು.
Yes, my lords. ಈಗ my lords,
It is slab.
my lords felt that Vishwas's case covers it.
Yes.
They, in fact, there are two more cases, my lords, when it comes to architects, my lords.
ನಾನೇ ಎರಡು ಮೂರು ಬರ್ದಿದ್ದೇನೆ.
Yes, my lords. Can I just pass these two, my lords? When it comes to architects, my lords, 304 doesn't apply. Again, my lords, a reliance has been placed on a Supreme Court ruling. In both of those, my lords. Both architects, they quashed, my lords. And
Both-
here,
both architects.
Yes, my lords. Adralli, in the second matter, my lords, his lordship, Justice Kunna's case, my lords, A1 was a person who constructed. 2 and 3, my lords, they had to do nothing with the construction. So he quashes it insofar as 2 and 3. 3 is the architect, my lords. And even in the other case where a bridge collapses, architect, they quash it, my lords. In our case, admittedly, he's the architect. In fact, my lords, the plan which he submitted, that plan was cancelled. Another plan which was submitted, my lords, where the architect does not sign, it goes on that basis. Ultimately, structural engineer and the constructors, my lords, they're the ones who have done this.
You're holding on Vikram sir also. Both of you are here.
Yes, my lords, we'll be leaving today together.
Sure, huh?
Sure. 2 days.
Vikram sir is also here. He's busy talking. Yes.
So, my lords, it's covered by all these decisions, my lords. So it's an architect. In fact, my lord's judgment itself, only if the names change, that's done, my lords. Quashment of the proceedings.
Page number 49 ದಲ್ಲಿ that the ಐದನೇದವನು ತನ್ನ
ಅದೊಂದೇ ಅಂಡರ್ಟೇಕಿಂಗ್ ಏನೋ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ.
ಅಲ್ಲ ಅಂಡರ್ಟೇಕಿಂಗ್ ಅಲ್ಲ ಅಂಡರ್ಟೇಕಿಂಗ್ ಅಲ್ಲ
I have filed the detailed objection in contending that matter.
ಈಗ
He was
ಯಾರ ಮೇಲೆ
supervised.
ಪ್ರೊಸೀಡ್ ಆಗ್ತೀರಾ ಇದಕ್ಕೆ?
A1 to A4, the persons who constructed the building, they're
They
there.
are the owners of the property. They are the
Owners of the
Owners and
property.
they were the one who
owners and
constructed.
constructors.
All right, who constructed?
They themselves,
Renuka
my lord,
Devi
under
construct.
supervision of my lord, under supervision of petitioner, they are constructing.
Who constructed the building?
That is the, my
If
lord,
the construction is so shoddy and 1 to 4 have undertaken construction, it is their responsibility. What
here,
will an
my lord,
architect do under
here,
304
my
years, sir?
there is a prescribed form in the, my lord, while obtaining the permission from construction, he has given undertaking form, my lord. It is Anusuchi 3 form, my lord. ಮೇಲ್ವಿಚಾರಣೆ ನಮೂನೆಯಲ್ಲಿ he himself has, my lord, given the undertaking.
architect?
Please. He is supervising the construction.
ಈಗ ಯಾರು families ಏನು ಕೊಟ್ಟಿಲ್ವಾ? ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿಲ್ವಾ?
Compensation, no, I don't.
No, 1 to 4 ಇಂದ ಅವ್ರನ್ನ ಬಿಡಬಾರ್ದು ಅಂತ.
ಅದು ನನಗೆ
So they're there. 1 to 4 are there. They're facing the trial, my lords.
ಇದರಲ್ಲಿ my lords, page 49 ದಲ್ಲಿ
Architect wise, my lords, now they've produced one certificate, so-called a work completion certificate, not for supervision.
column 17 my lords, page 49. My lords, he has destroyed all the my lords, the data relating to this building.
That is
Sorry,
201.
my lords, please notice what is collected. We have it in the chart sheet. Just pass it. It is sent to the FSL, no report obtained. They've taken 2 servers from me, 1 pen drive, mobile phone, no report.
ಅಲ್ಲ ಅದೇ ಅದರಲ್ಲೇ ಡಿಸ್ಟ್ರಾಯ್ ಮಾಡಿದಾರ ಅಂತ ಇರೋದು.
Everything is fine. Why did you take the pen drive?
ಅಲ್ಲ ಡಿಸ್ಟ್ರಾಯ್ ಮಾಡಿದಾರೆ ಅಂತ ಏನು ಅಲಿಗೇಷನ್ ಇರೋದು, they have destroyed everything.
They've taken my
That is the
servers
allegation.
to send it to the FSL. My lords, according to them, deleting of certain emails. They've taken my servers. They've taken the phone. They've taken pen drive, sent it to FSL. ಅದು pen drive. ಅದು ತಗೊಂಡಿದ್ದಾರೆ. I do understand, my lords, pen drives. Page 25 ಅಲ್ಲಿ.
It's become the most dangerous object in pen drive.
It's in page 25 that has been seized. Later they send it to the FSL, no reports at all.
ಮತ್ತೆ ಏನ್
And 201, how would it come, my lords? Destruction of evidence when you have taken the servers, you have taken the mobile.
Whose handwriting is this? Oh, sorry. Very nice. Yes.
So 201, destruction of evidence to go viral.
That my lord is the architecture of the building. That is not true. That is, my lord, he under his supervision only, my lord, the building was constructed.
Sorry.
Sir, architect will design.
No, my lord, that is the, my lord, that is the undertaking, my lord, he has given
ಈಗ
for the
architect ಹೌದಾ?
authority. ಅಲ್ಲ even, my lord, even his
Architect
architecture.
ಹೌದಾ?
ಅಲ್ಲ, that we are not disputing that, my lord, is.
Yes.
But he is. My objection may be, my lord, taken into
The
consideration.
petitioner is ಒಬ್ರೇ ಅಲ್ಲ?
ಒಬ್ರೆ
The petitioner
number
is
5.
before this court calling in question proceedings in special CC 1 of 2019 registered for offences punishable under section 304, 201, 420, 465, 468 and 471 of the IPC. Heard the learned senior counsel Sandesh Chowta appearing for the petitioner along with Sanya and learned counsel, learned AGA and
CS.
so and so. Who is on record otherwise?
Yes, Patil. Spot number 2.
Suresh, my lords.
Yeah?
Suresh Shettam now.
Over the hospital. Yes. So and so. It becomes unnecessary to narrate the facts in detail as this court, in so far as it concerns the accused number 6, has quashed the proceedings in writ, quashed the proceedings qua accused number 6 in writ petition 143858 of 2020 in terms of its order dated 22nd September 2023. Therefore, it would suffice if the findings rendered therein are paraphrased to the subject order. This court has held as follows, para 2 in the end or go. The learned senior counsel Sandesh Chowta, by taking this court through the charge sheet so filed and the findings as obtaining in column number 17, as also the documents appended to the charge sheet, would demonstrate that the petitioner is in fact an architect who has designed the property. The construction is undertaken by accused number 1 to 4. The factum of the petitioner being an architect is not disputed by the complainant even. In that light, whether an architect who designs a particular building can be hauled up for offences under section 304, i.e. culpable homicide, or death by rash or negligent act as obtaining under section 304A, is required to be considered. The consideration of which the architect need not detain this court for long or delve deep into the matter. As this court, in answering an identical circumstance in writ petition 5609 of 2022, has held as follows in its order date, held as follows. Quote the entire order. The aforequoted order in the case of Vishwas V was also concerning an architect who had been hauled into the web of proceedings for offences punishable under section 304A or 304A IPC. In 304 or 304A na?
4A, my lords, Vishwas.
Alla, illi
304.
304A. In the case at hand, what is alleged is 304. 304 reads as follows. 304 mandates, 304 deals with offence punishable for death by culpable homicide. Death by culpable homicide. The said section would not even get attracted in the case at hand, as what is necessary for section 304 is mens rea, mens rea and the intention to kill. So that cannot be present in the case at hand, even in its remotest sense. Whether the offence would attract 304A, then will follow that. 304. In the light of the said circumstance, permitting further proceedings against this petitioner would become an abuse of the process of the law and result in miscarriage of justice. The learned counsel for the complainant would vehemently refute the submissions of the learned senior counsel to contend that the entire supervision of the construction of the building was undertaken by the fifth respondent and would seek to place certain documents to that effect.
Petitioner. Fifth respondent, petitioner.
Fifth accused.
Fifth accused. Accused number 5, the petitioner. The learned counsel would seek to place on record certain documents to that effect. I decline to accept the said submission, as the architect cannot be rendered with the job of supervision of construction even when construction is admitted by accused number 1 to 4. Therefore, the aforesaid reasons allowed quashed. ಇನ್ಯಾವ್ದಾರು ಇದೆಯಾ?
ಇಲ್ಲೇ petition copy ಕೊಡಿ.
ನಿಮ್ದು ಇನ್ಯಾವ್ದಾರು ಇದೆಯಾ?
Palwan,
ಒಬ್ಳೆ
Demot,
ಅದು ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್ ವಾಪಸ್. ಅಲ್ಲ ಇದು ಈ ಕಾಪಿ.
Please, the offense urged against the petitioner is section 420 and section 420.
420?
420 of IPC.
420?
420
ಹಾ.
of IPC.
ಕರೆಕ್ಟ್, IPC ಇರೋದೇ 420.
Please.
ಹೇಳಿ.
And section
ಅದು
7.
ಇವಾಗಿಲ್ಲ.
Section 19 and.
The biggest advantage of or disadvantage of BNS is no 420. 420 is not cheating.
Please.
It is 351. Yes.
Please. And section 7 and 19 of Fertilizers Act. The present petitioner is accused number 5. Is a godown owner in which the fertilizers were stored. He had given the godown on rent. He has nothing to do with the fertilizers which has
What
been
is the
seized.
rental agreement?
Please,
Rental agreement.
rental agreement has not been produced in the charge sheet, but in the recovery Panchnama, it has been stated by the accused number 1 and 2.
Where is the rental agreement?
I pray to kindly see the.
Where is the rent? You had given it on rent.
Please.
Where is the rental agreement?
I have given it to the rent on the one person name called Prabhu. He had given the rent to another person.
Prabhu ಕೊಟ್ಟಿದ್ದ rent agreement ಇಲ್ಲಿ.
Prabhu kottid rent agreement that has not been produced. But I pray to kindly see the recovery Panchnama. It has been stated clearly by the accused persons that they have taken the godown on rent by the name called Prabhu, and it belongs to the petitioners. It has been produced at page number.
They are
35. 35 may kindly be seen. Recovery Panchnama.
They are selling the molars
Relevant para is
fertilizer 640 rupees ಇರೋದು ನ್ಯಾಷನಲ್ ಯಾವುದೋ ಕಂಪನಿದು ಫರ್ಟಿಲೈಸರ್ ನ ಅದು DAP ಅಂತ ಹೇಳಿ ಮೊಲಾಟ್ ಜೈ ಕಿಸಾನ್ ಕಂಪನಿ ಅಂತ ಹೇಳಿ ಚೇಂಜ್ ಮಾಡಿ ದೇ ಆರ್ ಸೆಲ್ಲಿಂಗ್ ಟು ದ ಫಾರ್ಮರ್ಸ್ ಮೊಲಾಟ್ಸ್ ದಟ್ ಕ್ಯಾನ್ ನಾಟ್.
No sir.
And in present case, company has also not made as a party also.
ಅದು
Recovery Panchnama.
ಮಾಡೋದೇ ಇಲ್ಲ ಬಿಡಿ. Anyway, list on Friday, 21st. It has to be before me only, don't worry.
Please. Interim order earlier granted.
Testing will continue to the.
I'll produce the rental agreement.
Produce that.
Please.
You should get everything, sir.
Please.
112, Avinash Mali Patil.
Petition number 1 is the Milord's retailer Milords. Petition number 2 is the Milord's seeds company Milords. Complaint is the agriculture officer Milords.
Substandard seeds molars. ಬಿತ್ತನೆ ಬೀಜ
7 and 3. 3 and 7, sorry.
There is a report to that effect that molars ಬಿತ್ತನೆ ಬೀಜ ಕಳಪೆ ಮಟ್ಟದ್ದು ಆಗಿದ್ದರಿಂದ. This is also molars again cheating the farmers.
Friday barley. Be ready in all these.
Please.
Please.
Interim order substitute.
Connected also Milords.
113, Vidyavati Amkotur Sitter. Jay Gachinmat.
ಅದು ಕನೆಕ್ಟೆಡ್ 112.1 ದಲ್ಲಿ without license he has stored the seeds.
ಅದಕ್ಕೆ
Please.
21st to get ready, sir.
In this case, my lord, your lordship kindly come to annexure L, page number 70, my lord. The Tahsildar recommended for reissue the license in favor of the petitioner in view of the acquittal order passed by the JMFC court. Annexure L, my lord. Page 70. Subject is B. So and so ಇವರು ರದ್ದುಪಡಿಸಿದ ಪ್ರಾಧಿಕಾರ ಸಂಖ್ಯೆ so and so ಅನ್ನು ಪುನಃ ಚಾಲ್ತಿಗೊಳಿಸುವ ಬಗ್ಗೆ. ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಮೆಲಾಡ್ ಕೆರೆಮಲ್ಲಾಪುರ ಗ್ರಾಮದಲ್ಲಿ 26/1/24 ವಶಪಡಿಸಿಕೊಂಡ 970 ಲೀಟರ್ ಸೀಮೆ ಎಣ್ಣೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಪ್ರಾಧಿಕಾರ ಸಂಖ್ಯೆ so and so ಅನ್ನು ರದ್ದುಪಡಿಸಿರುತ್ತಾರೆ. ಸದರಿ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಾಗಿರುತ್ತದೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಸದರಿ ನ್ಯಾಯಾಲಯ ಅಂಗಡಿ ಮಾಲೀಕರನ್ನು ದೋಷ ಮುಕ್ತಗೊಳಿಸಿ 19/8.
Interim order ಇಲ್ವಾ?
Please, Mela.
Interim order ಇಲ್ವಾ?
Revocation.
No,
They are seeking
interim.
revocation of the molars license.
Revocation
Already
of the license.
cancelled.
Because what happened, my lord, the deputy commissioner.
PDS.
Yes, my lord. The deputy commissioner cancelled my license on the ground that, my lord, there is a theft of 970 liter kerosene. Kerosene, my lord. Thereafter, my lord, I have preferred an appeal. In the appeal, they stated that materials is not produced, relevant document is not produced. All records are before the JMFC court, my lord, and against which I have preferred a writ petition. During the pendency of the writ petition, I have acquitted in the JMFC court. But the learned single judge passed an order, your lordship kindly come to page number 34, stating that, my lord, criminal cases was registered against the petitioner and illegally storing the kerosene. Accordingly, the second respondent by complying the
Adilwala. Crime is
crime is
ended in
not
fa-
there.
in favor of the
Therefore, my
Already,
lord, for
already it
the
is cancelled.
It's all
And if it
right.
is, my lord,
If the
ಅಲ್ಲ
cancellation-
ಬೇರೆದವರಿಗೆ ಕೊಟ್ಟಿದ್ರೆ ತೊಂದರೆ ಆಗತ್ತೆ ಮತ್ತೆ
ನಿಮಿಷ.
ಇವರಿಗೆ
Cancellation is on the basis of the criminal case, then it has to go.
ಅಲ್ಲ ಬಟ್ ಇಟ್ ಇಸ್ ಆಲ್ರೆಡಿ ಬೇರೆಯವ್ರದ್ದು ಕೊಟ್ಟಿದ್ರೆ ತೊಂದರೆ ಆಗತ್ತೆ.
ಬೇರೆಯವರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ.
If not given, my lords, then it can be considered. If it is given, my lords, then again it will.
Get the
Respondent number 4 is a party.
Vidyavati madam, I'll take it on Tuesday.
Please.
The learned counsel, Sri Vidyavati Kottur Shettar, submits that the license of the fair price shop allotted to the petitioner stood cancelled on a solitary score that the petitioner had incurred ineligibility of getting embroiled in a crime. The said cancellation was challenged before this court in coordinate bench of this court. Sorry, before this court in writ petition 106305 of 2015. The said writ petition comes to be dismissed in terms of the order dated 20th November 2020 on the score that criminal proceedings were pending. The petitioner gets acquitted of the offences. Therefore, the
Even writ appeal is also filed, my lord.
ಅದರ ಮೇಲೂ ಹಾಕಿದ್ರಾ?
Yes, my
ಅದೇನಾಯ್ತು?
Intra-court
Confirm.
appeal, we cannot go into question of the fact. Yes.
The appeal filed against this Albarkole, appeal filed against the said order also comes to be dismissed. The learned ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದಾರಾ ಈಗ?
Yes, ma'am.
ನೀವು ನಡೆಸ್ತಾ ಇದ್ದೀರಾ?
ನಡೆಸ್ತಾ ಇದ್ದೀನಿ.
ಮತ್ತೆ ಹೆಂಗಾಗ?
No. Your lordship kindly see respondent number 4 is the cause for everything. Now he is distributing for 1114 cards. As per the clause 11 of the PDS control order, minimum is 500.
Additional ಮಾಡು.
It is transferred to his society.
ಅಲ್ಲ,
All my
ಅರ್ಬನ್
cards.
ಆದ್ರೆ 800, ರೂರಲ್ ಆದ್ರೆ 300.
500. Now, in view of the
Now
amendment,
500.
it is 500. Now he is distributing 1114.
ಅಲ್ಲ above 500 ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ, above
Plus
500 ಎಷ್ಟು ಬರುತ್ತೆ?
ಬೇರೆಯವರು ಮಾಡ್ಲಿ 800 ಮ್ಯಾಕ್ಸಿಮಮ್ ಅಂತಿದೆ ಅದರಲ್ಲಿ.
Please.
It is within limits, my lords, because it has been distributed between two persons.
800 maximum ಇದೆ 1000.
It is
Therefore,
distributed between two persons.
the learned AGA shall secure instructions with regard to number of cards the fourth respondent who is now allotted the fair price shop from the hands of the petitioners as to the number of cards being distributed, cards being allotted to the fourth respondent, and the subsistence of the fourth respondent as on today. The instruction shall be sought and submissions be made on the next date of hearing. Yes. 20th.
Please.
Fresh
Fresh
list.
matters.
Please.
20th.
ಮುಗಿಸ್ಬೇಡ.
Final hearing matter 114. Matlappa.
Hirapur. My lord,
Madam.
petitioner has placed on independent charge.
2011 na?
2011, sir. Placed on independent charge from 5/6/99.
Karnataka University. You're appealing for the university, madam?
Yes, madam. I'm permitted to file the objections, madam.
2011 na?
Or hakirlilla when I got the matter. Your lordship,
ಹೇಳಿ
I'll
sir.
file.
And rendered 3 years service of on independent charge.
Independent charge.
Independent charge. As per KCSR rule number 32.
La, independent charge under rule 32.
Rule is 32.
Rule 32, 6
Rule
months
32.
ಮೇಲೆ continue ಹೆಂಗ್
Instead of
ಮಾಡಿದ್ರೆ
appointing a government servant.
I know, sir. Rule 32, I'm aware.
Okay.
Rule 32 is ad hoc arrangement for 6 months. Yeah.
ಆದ್ರೆ ಅವ್ರು ಕಂಟಿನ್ಯೂ ಆಗಿ 3 ವರ್ಷ
3 ವರ್ಷ ಮಾಡಿದ್ರು.
ಮಾಡಿದ್ದಾರೆ ಸರ್.
ಆಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರು?
ಆಮೇಲೆ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಸರ್ ಅವರು ನೆಕ್ಸ್ಟ್ ಅದನ್ನು ವಿಡ್ರಾ
ಕೇಡಲ್ಲಿ ರೂಲ್ 32 ಅಲ್ಲಿ ಇಟ್ರು ನಿಮ್ನ.
ಅವರು ಅಸಿಸ್ಟೆಂಟ್ ಆಫೀಸ್ ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಇದ್ರು ಸರ್. ಅಸಿಸ್ಟೆಂಟ್ ಆಫೀಸ್ ಸೂಪರಿಂಟೆಂಡೆಂಟ್. ನೆಕ್ಸ್ಟ್ ದೆನ್ ಆನ್ವರ್ಡ್ಸ್ ಅವರು
ಅಸಿಸ್ಟೆಂಟ್ ಆಫೀಸ್ ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಯು ಆರ್ ಅಂಡರ್ ರೂಲ್ 32. ಆಮೇಲೆ
ಅವರು ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ರು ಸರ್. then the respondent university withdrawn the earlier independent order. 2002 ವಿಡ್ರಾ ಮಾಡಿಕೊಂಡು ರಿಅರೇಂಜ್ಮೆಂಟ್ ಮಾಡಿದ್ರು. Annexure D ಪೇಜ್ 17 and 13 ಸೊ ನಂತರ ಏನ್ ಮಾಡಿದ್ರು ಸರ್ ಅವರಿಗೆ 4/3/2001 ಪೇ ಫಿಕ್ಸೇಷನ್ ಮಾಡಿದ್ರು. ಅಂದ್ರೆ ಅವಾಗ ನೀವು ಎಲಿಜಿಬಲ್ ಆಗ್ತೀರಿ ಅಂತ ಅನ್ನೋದಕ್ಕೆ ಪೇ ಫಿಕ್ಸೇಷನ್ ಮಾಡಿದ್ರು. ಪೇ ಫಿಕ್ಸೇಷನ್ ಮಾಡಿ ಆದ ನಂತರ ಅವ್ರು ಜೂನಿಯರ್ ಮೋಸ್ಟ್ ಎಂಪ್ಲಾಯಿನೂ ಅವರು ಪ್ರಮೋಷನ್ ತಗೊಂಡು ಎಲ್ಲ ಸರ್ವಿಸ್ನಾಗ ಇದ್ರು. ನೆಕ್ಸ್ಟ್ ಅವ್ರು ಒನ್ ಆಫ್ ದಿ ಕಲೀಗ್ ಶ್ರೀಮತಿ MU ಕವಳಿ ಡೆಪ್ಟಿ ರಿಜಿಸ್ಟ್ರಾರ್ ಅವ್ರಿಗೆ 99ಲಿಂದ ಇಂಡಿಪೆಂಡೆಂಟ್ ಚಾರ್ಜ್ ಹಿಡ್ಕೊಂಡು ಪೇ ಫಿಕ್ಸೇಷನ್ ಮಾಡಿದ್ರು.
ಮಾಡಿಲ್ವಾ?
ಮಾಡಿ ಸರ್. ಪೇಜ್ 47 and 48 Annexure G and H.
ನಿಮಗೆ ಆ ಬೆನಿಫಿಟ್ ಕೊಟ್ಟಿಲ್ಲ?
ಇವ್ರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ, ಬೆನಿಫಿಟ್ ಕೊಟ್ಟಿಲ್ಲ.
ಯು ಆರ್ ರಿಟೈರ್ಡ್ ನೌ?
Retired now, sir. Sir, now he is 78 years old.
78 years?
8 years old, sir.
ಮತ್ತೆ ಪೆಟಿಷನ್ ಯಾವಾಗ ಹಾಕಿದ್ರಿ?
2011.
ಹೌದು, ಕರೆಕ್ಟ್ ಟೈಮಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. ಪೆಂಡಿಂಗ್ ಇದೆ. Yes, madam, that's the only thing. Whether he is entitled to that pay fixation, taking that service rendered.
As can be seen from Annexure C, he was on a temporary basis, my lord.
Not temporary, madam. Rule 32 has some
Correct,
significance.
But the thing is that, my lord, here particularly they have stated when there is a vacancy.
Page Annexure C. Rule 32, where is the order post placing him on Rule 32?
Annexure D, my lord, sorry. Annexure D, page 17.
One moment. In view of the non-teaching
Moreover,
post-
they have not challenged Annexure E, my lord, which is the order.
1 minute, madam. Where is the order appointing him, giving him Rule 32?
Annexure D.
Page number 19, sir.
Office
Page number
superintendent
19, Assistant Office Superintendent, serial number 2.
Retained to work in category 1 cell.
Starting Annexure D ಅಲ್ಲಿ and page number 17 on 2/7/2002, my lord. There is a order that is the independent charge arrangement of various non-teaching posts in the university.
Where are you reading?
Page number 17.
Ah.
Starting itself, my lord, office order.
Independent
Subject.
charge arrangement of various non-teaching posts in the university.
In view of the final seniority list of KU non-teaching employees published under above referred notification and withdrawal of earlier independent charge, in charge arrangements following independent charges arranged out to the various non-teaching vacant posts are made. And at page number 19, he was appointed as Assistant Office Superintendent, my lord, at serial number 2, my lord. Wherein, my lord, in the last page, page number 23, my lord, the arrangements made on
It's
independent
purely
charge
temporary. That
is
is all right.
purely.
But Rule 32 appointment, madam, will not be temporary. In the sense, if you see Rule 30, if it is under Rule 32, what other way of independent charge is there? That's not there. KCSR Rule 32 nodidre. It is independent charge when he is eligible to be promoted to that post and cannot be promoted for various reasons. He will be posted under Rule 32. But ಅದು temporary ಹೌದು in stricto sense, but ರಿಟೈರ್ ಆಗೋವರೆಗೂ ಅದರಲ್ಲೇ ಕಂಟಿನ್ಯೂ ಆದ್ರ?
ಇಲ್ಲ ಸರ್, ನಂತರ ರಿಟೈರ್ಡ್ ಆಗೋ ಮುಂದೆ ಸೂಪರಿಂಟ್ ಆದ್ರು, ಆಫೀಸ್ ಸೂಪರಿಂಟ್ ಆದ್ರು ಅವರು. AOS ಆದ್ರು 2001
ನಿಮ್ಗೆ ಡಿನೈ ಮಾಡಿದ್ದು ಯಾವಾಗ?
ಡಿನೈ ಮಾಡಿದ್ದು Annexure A and B, ಸರ್.
ಅಬ್ಜೆಕ್ಷನ್ ನೋಡಿದ್ದೀರಾ ಅವ್ರದ್ದು?
ಜಸ್ಟ್ ಈಗ ಕೊಟ್ರು ಸರ್.
ಈಗ ಕೊಟ್ರ?
ಸರ್, ರಿಟ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಇಫೆಕ್ಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಪ್ರಾವಿಷನ್ ಅದ ಇದ್ರಾಗ.
PPP ರೂಲ್ಸ್ ಕೊಡಿ.
As per rules, I have produced.
Madam, two things you have to see. One is Rule 32 and there is Karnataka Civil Services.
Please, my lord, I have produced it along with my objections, my lord.
Adರಲ್ಲಿ there is, if he is holding post under Rule 32,
promotion,
it can be considered for retrospective
effect.
It can be considered for refixation of pension and pay. That's what
number 2, promotion number 2, sir.
You have dealt with that here?
No.
You will see that.
And moreover, here, my lord, the other post which has been allotted, that is, they have directly recruited, my lord. But the thing is that in this particular case, my lord, he was a there's a circular, my lord, which has been issued on 28/1983 and 29/1983, my lord. There's a retrospective effect for the promotions, my lord. And subsequently, my lord, this one Bilgi who has been appointed, he was a stenographer, and the petitioner was appointed as a junior clerk, my lord, initially. So accordingly, my lord, as per the rules, I have produced it.
My lord,
1 minute, yeah. He's telling something, wait. Madam, one thing.
Yes,
See this, he is appointed on independent charge in the office, assistant office.
Assistant office.
Superintendent, whatever it is. He continues in that cadre for 3 years.
Correct.
Then he is promoted as office superintendent.
Office superintendent.
Was this period taken note of while promoting? One thing.
I'll just check.
Then under the PPP rules, an employee is entitled to get his pension and pay refixed if he is holding charge on independent basis under Rule 32. There is no other rule here in the university. It is only KCSR. You just have to seek instruction on those two aspects. With regard to this rule, PPP rules.
I'll just.
Ashta, if that is there, then. But what is not challenged until you told me?
Annexure E, my lord. They have challenged only the communication letter.
What is annexure E?
They have made two representation at annexure A and B. For that, they have challenged it, my lord. But insofar as the order of pay scale that is at annexure E, my lord, 8/1/2010, that has not been challenged. Basis on that only the representations of annexure A and B has been
Let's see.
replied.
The 80-year-old employee will see new instruction clearly. If with regard to this, you seek instructions.
Please.
I'll take it on Monday.
Monday
or Tuesday, whenever you want. Tuesday, na?
Tuesday,
fresh matters will tagombiಡ್ತೀನಿ. So 2011 will finish.
Please.
One. Yes. That's the only thing is entitled. Our promotion ge tagombiಟ್ಟಿದ್ರೆ, see, if while promoting him as office superintendent, if these 3 years that he has held independent charge is already taken, it's over. ಇದೇನು ಬೇಕಾಗಲ್ಲ ಅವಾಗ. ಅದಷ್ಟೇ ಕೇಳಬೇಕು.
ಸರ್ ಒಬ್ಬ ಎಂಪ್ಲಾಯ್ ಕೊಟ್ಟಾರ 47 ಪೇಜ್ ನಂಬರ್ 47.
ಅಲ್ಲ ಅದು ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ರೆ ಮತ್ತೆ ಸಿಗಲ್ಲ ನಿಮ್ಗೆ ಅದು ಬೆನಿಫಿಟ್.
ಇಲ್ಲ ಸರ್, ಅವರಿಗೆ ಫಿಕ್ಸೇಷನ್ ಆರ್ಡರ್ನಾಗ
ಆಫೀಸ್ ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಪ್ರಮೋಟ್ ಆಗ್ಬೇಕಾದ್ರೆ ಇಂಡಿಪೆಂಡೆಂಟ್ ಚಾರ್ಜ್ ಅರೇಂಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದ್ದಿದ್ದು 3 ವರ್ಷನೂ ಸೇರಿಸಿ ತಗೊಂಡಿದ್ರೆ ಪೇ ಅಲ್ಲೇ ಫಿಕ್ಸ್ ಆಗೋಗಿರುತ್ತೆ. ಸೊ ಮತ್ತೆ ಮಾಡೋ ಅವಶ್ಯಕತೆ ಇರಲ್ಲ.
ಅವ್ರಿಗೆ ಫಿಕ್ಸ್ ಆಗಿಲ್ಲ, ಪರ್ಟಿಕ್ಯುಲರ್ ನಮ್ಮ ಪಿಟಿಷನರ್ ಪೇ ಫಿಕ್ಸ್ ಆಗಿಲ್ಲ.
ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಟೇಕ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್.
ನಮ್ಗೆ ಆಗಿಲ್ಲ ಸರ್, ಅವ್ರಿಗೆ
ತಗೊಂಬೇಕಾದ್ರೆ ಅಲ್ಲಿ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಎಲ್ಲ ಫಿಕ್ಸ್ ಆಗಿ ಕರೆಕ್ಟ್ ಆಗಿ ಆಗಿರುತ್ತೆ. ನೌ ವಿ ಕಾಂಟ್ ಗೋ ಬ್ಯಾಕ್.
Yes, ma'am.
That's the only thing. If it is not fixed, please. Yes.
Non-compliance of office restrictions, case number 151. Where Salma?
ಇದನ್ನ ಕಂಪ್ಲೇಂಟ್ ಆಗಿದೆ. Learned counsel submits office subject. ಪೆರೋಲಾ?
Yes, your lordship.
ಪಾರ್ಟಿ ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ ಮಾಡಿದಾರೆ ಕಾಪಿ.
ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ ಪಾರ್ಟಿ?
Your lordship, premature release ಇದರಲ್ಲಿ ಗೈಡ್ಲೈನ್ಸ್ ಪಾಸ್ ಮಾಡ್ಬೇಕಂತ ಹೇಳ್ಬಿಟ್ಟು ಬ್ಯಾಂಗ್ಳೂರ್ ಬೆಂಚ್ ಅಲ್ಲಿ ನ್ಯೂಲಿ ವಿ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ your lordship.
State government party. List on Monday in the fresh matters list. Office objections overruled. Yes.
152 DL Ladkhan.
Non-payment of court fee. The cost. A week's time is granted to do the needful. 153, 154.
53, 304 ಇದೆ. 304 ಕೊಡ್ಬೋದು ಅದನ್ನ 30 days ಕೊಡಿ.
153.
53.
The 153, the petitioner. Salma madam, who is this? Who is the petitioner?
Mother, your lordship. Mother.
The petitioner is the mother of the convict who is sentenced to imprisonment for a period of 3 years. 3 years parole baralwala?
Your lordship, 2 years ಬರುತ್ತೆ. 2 years.
2 years ilva? The petitioner total is the mother of a convict who gets convicted for offense punishable under section 304 part 2 of the IPC and is said to have been sentenced to undergo imprisonment for 10 years, out of which the petitioner is already, the son of the petitioner has spent 3 years in prison
4 years, 5 months.
4 years, 5 months. 4 years, 5 months, including remission. 4 years, 5 months in prison. The mother of the petitioner has now filed an application seeking release of her son on parole. First time, madam?
Yes, Your Lordship.
And the learned counsel for the petitioner submits that this is the first parole that the son of the petitioner, the mother is seeking, mother is seeking in favor of the son. In that light, for the son, the learned additional SPP, sorry, learned AGA on instructions would submit that the conduct of the petitioner as there is no adverse entry on the conduct of the petitioner, and the report in ಕೊಡಬಾರದು ಅಂತಾನೆ ಇರೋದು.
ಅಲ್ಲ, ತೃಪ್ತಿಕರ ಇದರಲ್ಲಿ
conduct of the petitioner. In that light, I deem it appropriate to grant the petitioner parole for a period of 60 days. Yes. So it's to Monday to become operational from Monday. Yes. 17/4, 60 days. 60 days. Yes.
Kidnap, rape, robbery.
Kidnapping.
Kidnap, rape, robbery.
Huh?
Kidnap, rape and robbery.
Your Lordship, already 30 days he had been granted and he went back to
Gone. List on Tuesday in the fresh matters list. Yes.
155.
ಇದು ರೇಪ್, ಮರ್ಡರ್ಸ್, ರಾಬರಿ ಅಂಡ್ ಮರ್ಡರ್. ಎಮರ್ಜೆನ್ಸಿ ಫಾಲೋವರ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ ಅವರು, ಅದನ್ನ ರಿಜೆಕ್ಟ್ ಮಾಡಿದೀವಿ. ಎಮರ್ಜೆನ್ಸಿ
Tuesday office objections overruled. 1 minute, madam. Office objections overruled. List the matter on Tuesday in the fresh matters list.
Obliged, Your Lordship.
Yes. Kodi.
Fast over. List 2, serial number 3.
Is it, madam? B group 230.
Let's appear for the petitioner. This is the reservation matter.
Reservation matter. ಅದು ಕರೀರಿ ಒಂದು ನಿಮಿಷ. Wait, ಕಡದ್ ಕಟ್ಟಿವ್ರಿ ಒಂದು ನಿಮಿಷ. ಒಂದೇ ನಿಮಿಷ.
156.
Yes, Abhishek.
Patil.
Pleadings complete,
No, Your Lordship. I have to file, Your Lordship.
Familiar.
Illa,
It has serious consequences. Be very careful.
Please, Your Lordship. That's why I will file objections, Your
You have
Lordship.
to file objections.
Please, Your Lordship.
Because an order in their favor will have serious consequences.
Please, Your Lordship. I'll file, Your Lordship.
Yes, madam.
I'm for respondent number 6 and 7, my lords.
ನೀವು ಹಾಕ್ತೀರಾ?
We are already retired from the service, my lords.
Already retired from service.
Please.
Not bothered. Yes. Next, in ಯಾರು ರಿಟೈರ್ ಆಗಿದ್ದಾರೆ?
I will file objections, Your Lordship.
Yes. Learned HCGP seeks 2 weeks time to file statement of objections. List the matter on 14th March for further hearing.
Obliged.
Yes.
157, Ravi Hegde.
Regularization of service, my lord. There is already a recommendation by the fourth respondent to the second
ಯಾರಿಗೆ?
respondent.
KSRTC na?
ಅಲ್ಲ, PWD.
Huh?
PWD.
PWD?
Regularization.
ಕೊಡಿ. Synopsis ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ. Already filed synopsis. Annexure J is the recommendation, my lord.
86 appointment.
ಹೌದು. 86 and 93.
ಇಬ್ರಿದಾರಾ?
ಇಬ್ರಿದ್ದಾರೆ. Annexure
Sanction post.
Sanction post. Annexure J, page number 30, my lords, may kindly see.
Next year B, Your Lordship, page 14, Your Lordship. It has been directed that the Panchayati should take decision on its own, Your Lordship. May I kindly take, Your Lordship?
Panchayat will take, don't worry.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಿನಗೂಲಿ ನೌಕರರ ಸೇವಾ ಸಕ್ರಮಾತಿ ಕುರಿತು ಶ್ರೀಮತಿ ಉಮಾದೇವಿ ಪ್ರಕರಣದಲ್ಲಿ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಸಂವಿಧಾನ ಪೀಠವು ದಿನಾಂಕ ಸ್ವಯಂಸೋದಿಂದ ನೀಡಿದ ತೀರ್ಪನ್ನು ಆಧರಿಸಿ ಸರ್ಕಾರದ ಸಿಬ್ಬಂದಿ ಮತ್ತು ಆಡಳಿತ ಸುಧಾರಣಾ ಇಲಾಖೆಯ ನಿಯಮ ದಿನಾಂಕ 21/11/2006 ಸುತ್ತೋಲೆ ಹೊರಡಿಸಿರುತ್ತದೆ. ಸದರಿ ಸುತ್ತೋಲೆಯಲ್ಲಿ ಈ ಕೆಳಕಂಡ 4 ಷರತ್ತುಗಳನ್ನು ಪೂರೈಸಿದ ದಿನಗೂಲಿ ನೌಕರರ ಸೇವೆಯನ್ನು ಸಕ್ರಮಾತಿಗೊಳಿಸಲು ಅವಕಾಶವಿರುತ್ತದೆ ಎಂದು ತಿಳಿಸಲಾಗಿದೆ. ಅದರಂತೆ ದಿನಗೂಲಿ ನೌಕರರ ಸೇವಾ ಸಕ್ರಮಾತಿ ವಿಷಯದಲ್ಲಿ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರ ಸಮಕ್ಷಮ ಪ್ರಾಧಿಕಾರವು ಸಂಬಂಧಪಟ್ಟ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ಗಳ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಗಳು ಆಗಿರುವುದರಿಂದ ದಿನಗೂಲಿ ನೌಕರರ ಸೇವಾ ಸಕ್ರಮಾತಿ ವಿಷಯದಲ್ಲಿ ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿದ ಮನವಿ ದಾಖಲೆಗಳನ್ನು ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಹಂತದಲ್ಲಿಯೇ ನಿಯಮಾನುಸಾರ
ಜಿಲ್ಲಾ
ಪರಿಶೀಲಿಸಿ
ಪಂಚಾಯತ್ ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೆ?
my lord,
ನಿಮ್ಮ ಹಂತದಲ್ಲಿಯೇ ಮಾಡಬೇಕಲ್ಲ.
ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಸೂಚಿಸಲಾಗಿದೆ.
Please, I will take instructions, my lord.
What instructions?
Allah.
We will pass orders.
Yes.
Direct regularization.
There is already a recommendation, page number 30 param.
86 ರಿಂದ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಮಾಡ್ತಾ.
ಅಲ್ಲ, ಹಾಗೆ
They have fulfilled all the conditions, my lord.
Totally inhuman ಆಗ್ಬಿಡುತ್ತೆ.
ಬಹಳಷ್ಟು ಕೇಸಲ್ಲಿ ಹೀಗೆ ಆಗ್ತಾ ಇದೆ ಸರ್. ಬಹಳಷ್ಟು ಕೇಸಲ್ಲಿ
ಅದಕ್ಕೆ ಯಾವ್ದಾದ್ರು ಒಂದು ಕರೆಕ್ಟ್ ಆಗಿರೋದು ಸಿಗ್ಲಿ ಅಂತ ಇದು ಕರೆಕ್ಟ್ ಆಗಿದೆ. Where everything is found in this.
Yes.
ಸುಮ್ಮನೆ ಎಲ್ಲರನ್ನು ಕೋರ್ಟ್ಗೆ ತರ್ಸೋದು ಬೇಡ.
Yes. And there is a 40.
Pass some order now.
Please.
ಅಷ್ಟೇನಾ? Heard reserved. ನಿಮ್ಮ ಹಂತದಲ್ಲಿ ಏನಿಲ್ವಲ್ಲ ಬಿಡಿ.
ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಪೇರದಲ್ಲಿ ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ
ನೀವು
ಮತ್ತೆ
ಹಂತ
ಫರ್ದರ್
ಹಂತವಾಗಿ ಓದಿದ್ರೆ
ಅಬ್ಸರ್ವೇಷನ್
ಹೆಂಗಾಗುತ್ತೆ ಹೇಳಿ.
ಫರ್ದರ್ ಅಬ್ಸರ್ವೇಷನ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. They should go through the each cases, your lordship. All the cases are different, your lordship. No,
This case is genuine.
Yes.
your lordship, they blindly send, usually in all the cases I am saying, your lordship, they blindly send recommendation to government, your lordship. And
ಯಾರು ಕೆಲಸ ಮಾಡ್ದೇನೆ ಸುಮ್ನೆ
ಅಲ್ಲ ಹಾಗಲ್ಲ,
ಇಲ್ಲ ಅಲ್ಲ.
they should go thoroughly, your lordship, and
Thoroughly?
ಹೌದು ಎಲ್ಲಾನು each and everything, your lordship, all the 4 requirements of the conditions, your lordship, they never send like that, your lordship, in many of the cases, your lordship.
In this case, my
What
lord,
conditions?
ಅಲ್ಲ, ಉಮಾದೇವಿ conditions, your lordship.
All conditions have been fulfilled.
ಉಮಾದೇವಿ
ಇಲ್ಲ.
ಆದ್ಮೇಲೆ ನೀವು ಸರ್ಕ್ಯುಲರ್ ಇಶ್ಯೂ ಮಾಡಿದಿರಲ್ಲ.
ಇದರಲ್ಲಿ, your lordship, ಇದರಲ್ಲಿ ಇಲ್ಲ,
ಸರ್ಕ್ಯುಲರ್ ಅಲ್ಲಿ
ಹಾಕ್ಲಿಲ್ಲ ಇದರಲ್ಲಿ.
ಉಮಾದೇವಿ 1/4/2006 is Umadevi's judgment.
Please, please.
You issued a circular on 13/11/2006
6, your lordship.
quoting Umadevi. ಈ 4 ಕಂಡೀಷನ್ ಇದ್ರೆ ಆ ಸರ್ಕ್ಯುಲರ್ ಅಲ್ಲಿ ಫುಲ್ಫಿಲ್ ಮಾಡಬಹುದು. ಏನು ಎನಿ ರೆಗ್ಯುಲರೈಸೇಷನ್. But you never did regularization of any case taking that circular. You fell back upon Umadevi to deny everybody regularization.
Yes.
So ಏನಾಗಿದೆ, ಅವ್ರು 1986 ಇಂದ 2006 ವರೆಗೆ 20 ವರ್ಷ ಆಗಿತ್ತು. 2006 ಇಂದ ಇಲ್ಲಿವರೆಗೆ 18 ವರ್ಷ ಆಗಿದೆ. 38 ವರ್ಷ ಆಯ್ತು. ಈಗ where do you send them? Where do you send them? 38 ವರ್ಷ ಆದ್ಮೇಲೆ ಈಸ್ ರಿಟೈರ್ ಆಗಿದ್ದೀರಾ?
ಇಲ್ಲ, ಲಾಸ್ಟ್ ಲೆಗ್ ಆಫ್
ಲಾಸ್ಟ್ ಲೆಗ್ ಆಫ್ ಹಿಸ್ ಸರ್ವಿಸ್. ಈಗ ಏನು ಆಯ್ತು, ಅಲ್ಲಿ ಶಾಲ್ ಹೊತ್ಸ್ಬಿಟ್ಟು ಮನೆಗೆ ಕಳಿಸ್ಬಿಟ್ರಾಗಲ್ಲ.
It should be scrutinized, your lordship, whether
What
he is
should be scrutinized,
appointed to the post
See,
vacancy post.
you
your
should plug
lordship.
in the places where they are appointed in the beginning.
Yes.
Please.
ಸುಮ್ನೆ ಅಪಾಯಿಂಟ್ ಮಾಡ್ತಾ ಹೋಗಿ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ ಎಲ್ಲ. Problems have happened. 1986 ಇಂದ ಆಗಿದೆ. The policy of the state to appoint.
Before Umadevi, they have completed 10 years.
What is their mistake? Before Umadevi 20 ವರ್ಷ ಸರ್ವಿಸ್ ಕೊಟ್ಟಿದ್ರು ಇವರು.
They have completed. Annex page number 30 for a moment, kindly see, my lord. There is already a clear recommendation.
Recommendation by
Fourth respondent to the second respondent.
Very good. This will be the
Yes.
model case now. Yes, reserved.
Much obliged.
Before I go, I'll write this in.
Please.
ಆಮೇಲೆ ಫಾಲೋ ಮಾಡ್ಕೋಬಹುದು. Up to Shripal will consider everything.
I have enclosed
Where is
everything.
Shripal?
I have enclosed along with synopsis.
How citation?
My lord, I have
31st January.
Jaggo I have, my lord, given.
Jaggu ಗೊತ್ತು, Shripal?
Shripal on industrial disputes of
Yesterday.
31st January.
Jaggo, my lord, everything covers.
25 SSC online AC
Yes,
page
I have.
282.
Please.
ಬರ್ಕೊಳ್ಳಿ.
ಇದೆ ನನ್ನ ಹತ್ರ.
Pastor, serial number 3, ST Kadakpatti.
I make a submission. Seal number 149 ನೋಡಿ election matter lords.
149 urgency ಇದೆಯಾ?
So are the cooperative society. Big group. Voting power is
Voting ಬೇಕು.
ಆಗಿದೆ.
ಮತ್ತೆ ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ ಆಗಬೇಕು.
Election ಡಿಕ್ಲೇರ್ ಮಾಡಬೇಕು.
BMSP ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಸಾಹೇಬ್ರ ಆರ್ಡರ್.
ಹೌದು.
One submission. I am appearing for respondent 5 in this case, lordship. The cooperative society
dispose ಆಯ್ತಲ್ಲ?
149 is not disposed, lordship.
ಆಯ್ತು, will dispose it then.
Lordship, what happened, lordship? What the relevant that the act itself is not applicable, lordship. In my society is concerned, lordship. The cooperative, so are the act is applicable, lordship. Can you?
So are they? So are they?
They claiming under.
Let it come then. Yes.
In fresh.
Tuesday ಹಾಕಿ madam.
In fresh matter, lordship.
Fresh matters. Yes. Tuesday fresh matters.
The same lords. The parameters are same lords. So are they? And
he has some objection. We'll see Tuesday. Yes.
Please.
ಆಯ್ತು ಮೇಡಮ್. ಕಡದ ಕಟ್ಟಿ ಅವ್ರದ್ದು.
ಈ ನೋಡ್ ದಿ
Tuesday fresh matters list. 149. 149 ತಾನೇ ಅದು?
Annexure B, page 16.
Serial number?
Annexure B, page 16, my lord.
230.
Serial number, my lord, 3.
230.
Second list, 230, my lord. Sorry.
Yes, sir. ನೀವೆಲ್ಲಿದ್ರಿ ಕರೆದಾಗ?
Third court, my lord. Your lordship took the Bangalore matter, then, my lord. Sorry.
ಬೆಂಗಳೂರಿನವ್ರು ಧಾರವಾಡದಲ್ಲಿ ಬೆಂಗಳೂರು ಮ್ಯಾಟರ್. ಎಸ್. ಗುಡ್ ಗುಡ್.
My lord,
ಎಸ್ ನೋಡಿದ್ರಲ್ಲ?
They are most the, so for district, ತಾಲೂಕಾ level to district level. ಆ ಕಂಡೀಷನ್ ಇದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಆಯ್ತು, you seek instructions. Will stay it for 2 days.
ಅಲ್ಲ 80% of the turnover, 3 years turnover, ಅದನ್ನೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿ.
ಆಯ್ತು ನೋಡೋಣ ಮಂಡೇ. ಈಗ ಏನಿದೆ ಅರ್ಜೆನ್ಸಿ ಏನು?
my lord, urgency is, my lord, they, my lord, the within the mandatory period of 30 days, they have not complied. 36 crores is about 2 crores, my lord. It should be 30 days. It is, my lord, 15th day, 18th day, it is completing.
That after obtaining permission.
Not mandatory, it's direct. I have myself held it to be direct.
Alla division bench judgment.
ಅದೇ I myself held it to be direct in L&T, lesson and
yes, yes. That is one of the ground, my lord. Another is condition number 2 and 3, my lord. They, my lord, put the condition terms, my lord, including the COVID period. They put the tender amount is, my lord, 36 crores. They should have, my lord, carried the business of, my lord, 3 years, 2021, 21, 22 and 22.
We'll take it on Monday then.
Yes.
Monday fresh matters. Yes. Monday ಅಲ್ಲಿವರೆಗೆ ಏನು ಪರವಾಗಿಲ್ಲ, ಏನಾಗಲ್ಲ.
Please.
ಯಾವ್ದು ಮೇಡಮ್ ಇದು? ಎಷ್ಟಿದೆ? 8. ಕರಿ ನೋಡಿ, ಟೈಮ್ ಆಯ್ತು. ಜಗದೀಶ್ ಸರ್.
I'm sorry, my lord. Morning, some disturbance will happen.
ಅದ
Lord, could you lordship kindly turn
we can send it back to the assistant commissioner.
DCVC one.
DCVC. Now the council
ಅಲ್ಲಿ ಎರಡು ಕನ್ಸಿಸ್ಟಿಂಗ್ ಆರ್ಡರ್ ಇದೆ. Earlier Tahsildar has said that it belongs to Kunagar anta. Very same Tahsildar changes his stand. How could there be, my lord?
What do you do with such people?
ಅವ್ರ ಮೇಲೆಲ್ಲ ಈಗ ಆಕ್ಷನ್ ತಗೊಳಕ್ಕೆ ಆಕ್ಟ್ ರೆಡಿ ಮಾಡಿ.
Amendment has been made.
ಅಲ್ಲಲ್ಲ, ಈಗ amendment has been made for giving a false report. I pressurized the government, my lord. Now the government has taken, opened his eye, and now recently the amendment has been made. So page number 39 ನೋಡಿ.
Divergent certificates ಬರ್ತಾನೆ ಇರುತ್ತೆ, and these people are stuck now in the crossfire.
People are not enjoying what happened, my lord. Instead of reservation going to the needy person, it is going to the greedy person.
ಹೌದು. That is true. That is why is well, your F.A. Patil. Where is Pallavi?
Kindly have it on
ಮನೆಗೆ
next week.
ಹೋಗಾಯ್ತಾ? ಓ ಸರಿ ಆಯ್ತು.
Next week, your lordship.
Next week. Next Friday.
Yes.
All right. It's next Friday.
126 ಅಲ್ಲೂ ಹಾಗೆ ಇದೆ ಸ್ವಾಮಿ.
126 my lord, I appear.
126.
My lord,
126
already dismissal order has been quashed by this honorable court. My lord, way back in 2010, I have made a representation to reinstate. She is hardly having only three months for retirement.
ಅಲ್ಲ, division bench of High Court ಇದೆ. You can't reinstate it because as there is a cloud with regard to the caste status.
ಒಂದು ನಿಮಿಷ ಸರ್, ನಾಳೆ ಸೆಕೆಂಡ್ ಸಾಟರ್ಡೆ ಅಲ್ಲಲ್ಲ? ಸರಿ, ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
Bless.
ಎಸ್ ಎಸ್ ಮನ್ಮೋಹನ್, ನಿಮ್ದು ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಾ?
150
ಸೀನಿಯರ್ ಪಾಸ್ ಓವರ್ ಆಗಿದ್ದಾರೆ. ನಮ್ಗೆ ಟ್ಯಾಕ್ಸ್ ಕರೆಕ್ಟ್ ಆಗಿ ಕೂತ್ರೆ ಅವಾಗ ಸ್ವಲ್ಪ ಆಗುತ್ತೆ, ಇಲ್ದೇ ಕಷ್ಟ ಇದೆ. It's not, you simplified it so much that he was shocked. ಆಮೇಲೆ ತಗೊಳ್ಳೋಣ, ಅಂದ್ರೆ let it come. ನಿಮ್ದು ಮನ್ಮೋಹನ್?
150 lord, this relates to application of lord GST lord to ENA. The issue is lord
GST to
ENA, that is lord extra neutral alcohol, which is supplied lord to government of Karnataka lord KSBC.
We'll take it on Tuesday.
Can it be next Friday, lord?
Friday, fine.
You can request at 2:30 subject lord.
Friday 2:30 ಗೆ ಹಾಕೋಣ.
Great. The interim order may be continued, lord.
Interim order is there?
Howd. Lords had granted it on last.
That was opposed, my lords, but it was granted, my lords.
Friday.
My lords, and the one submission.
Not there, we'll take it at 2:30 on Friday and close it.
Please, one important aspect which I will bring to the notice of this honorable court is that, my lords, in a recent amendment, that is of 2024 amendment to the GST Act, my lords, the ENA is, my lords, exempted from the levy of GST.
Yes.
And to that effect, a notification is also issued, my lords.
I have produced all that, it's there.
But after the notification, that is 1/11/2024, my lords, it is exempted. Prior to that, it was liable for GST, my lords. I may be permitted to
I'll
insert
argue
the
that,
notification.
because
That's the only issue, that it may not take much time.
no, that is one of the issues, Lord. In addition to that, Lord, the question would be whether, Lord, how could they levy GST in respect of a product which is not specifically provided for?
Let's see.
That they have to answer.
My lord, serial number one.
Please.
Friday 2:30.
Please,
Yes,
Mr.
Clifton.
My lord, I'm appearing in serial 150.1, my lord. 121, please. This pertains to this refusal of regularization and then the consequent denial of compassionate appointment. My lord, that this matter, if it can be had on Tuesday, my lord, please, in the fresh matters.
Yalla fresh matter ಎಲ್ಲಿ ಕೇಳಕ್ಕಾಗುತ್ತೆ.
But I can only request, my lord, I know the pressure that the court is
First
under.
day I finished off fresh matters by 2:30, 200 idru. Now fresh matters, everything have come up here. So,
But this matter, my lord, has been pending for 2 years. And it's
ಎಲ್ಲ
because
2011, 12, 13.
other than note that I've been following the.
We'll see. I'm trying to dispose as much as possible. No, I'll take it.
Tuesday, if
Okay,
it's
come.
possible. On Tuesday.
Preliminary hearing ಅಲ್ಲ ಹಾಕಿ. 121. No, regularization, 1 or 2 orders I'll pass. It will cover the entire spectrum.
Idralli, just one thing is that this
No,
will
this
also-
particular concept, what you're telling.
Yes.
Regularization first, then date of death admile, that is considering compassionate appointment.
Yes.
You see a judgment of the apex court in 2021
Please,
on the
my lord.
same issue.
Please, my lord. I'll
On the
definitely
same
do
issue. There the employee had put his regularization was recommended. During the pendency of the recommendation, he dies.
Yes.
The court directs regularization consideration for appointment on compassionate grounds.
Please, my lord.
You get that judgment.
My lord was also asked for the what is the citation for Shripal? It is 2025 SCC online SC page 221.
Yes, correct.
Yes, no, my lord had asked for the citation a couple of hearings ago. So I just thought I'll just pass it on to my lords.
221, correct.
ಹೌದು 221 ಇದು.
That's what I said. I don't know. Yes.
Grateful, my lord. So Tuesday, my lords, serial mounted.
ಅದನ್ನ preliminary hearing ಹಾಕಿರಿ ಅಷ್ಟೇ.
Grateful.
Serial number 131 requesting for Wednesday, my lords.
18th.
Serial number 131, my lords.
Serial number?
131 requesting for Wednesday, my lords. From associate professor ಗೆ recruitment.
ನೋಡೋಣ ಮೇಡಮ್ ಯಾವ್ದಾಗತ್ತೆ.
130
I'm left with few days.
130 or what?
My lords, serial number 151, 150.1, my lords.
30.
My lords, I'm being led by Mr. Senior Counsel, Mr. Shankar, in that matter, my lords. Your lordship has given next Friday. Can it be the Friday after that, my lords? On
No problem. March first week ಅಲ್ಲಿ ಬರಲಿ.
7th of March, my lords.
Interim order ಇದೆಯಲ್ಲ?
Interim order.
Next Friday. Yes,
130 or what? 130 or what? Next Friday.
My lord, 133.
Interim order ಇದ್ರೆ ಮಾತ್ರ ಕೇಳಲೇಬೇಡಿ.
What happened, my lord? 3 times, my lord, listed in the same group. 133, my lord. Listed in the same.
Yes, sir.
Madam,